Well, welcome back, everyone. I think we had a great day yesterday getting started, and we're looking forward to another great day today. Joined by some new folks. Charles Ellison's with us now, Gordon Smith's with us now. Our moderator for the first panel today is Keith Paul Bishop, who's a partner in Alan Macken's corporate and securities practice group, working out of their Orange County office. Keith represents clients in a wide variety of corporate transactions, including public and private offerings of securities, mergers and acquisitions, proxy contests, tender offers, and a wide variety of other areas in our field. Keith is a leading expert on Nevada, corporate law, and has a wonderful blog that if you don't follow, you really need to follow Keith's blog. He covers the inanities of California corporate law better than anybody I know, and it is, for me, an incredibly valuable resource on I routinely go into class in corporations and business associations armed with some factoid about California corporate law that I learned from Keith's blog, that I can then convince my students that they are learning a little California law. So I'll turn it over to Keith now to moderate the first panel.
Well, thank you, Steve. I thought yesterday was really interesting, and the discussion was really interesting. And I guess if I haven't accomplished anything else at this conference, at least I've spread the gospel of the proper pronunciation of the state immediately to the east of California, sometimes known as Nevada. But I actually spent my formative years in the state, and it's interesting to me when I think back. They made us take Nevada history when we were in school. And for some reason, the introduction to the Nevada history text has always stuck with me, because it begins by describing the state, and this is the Nevada state history book, as a vast expanse of nothingness, stretching from nowhere to nowhere, a mean plain of ungodliness. So that's how I learned Nevada history, with those opening lines. I feel a bit like a token today. I'm a California lawyer. Spent my entire career practicing in California. So I deal a lot with California corporate law issues. But going back to the 1990s, because of my connection to Nevada and just coincidence, I ended up starting to write about Nevada and wrote a treatise that came out in 1993, and has been through various publishers over the years. It's been interesting to me that to see how Nevada has sort of attracted the attention, even of professors back at the Harvard Law School and at the University of Virginia. It's been kind of an interesting thing to see. Our first presenter today is Sean Griffith, who is from the Fordham Law School in New York. He's a graduate of Harvard Law School. He practiced at Wachtell Milken. He co-authored a number of articles with Jill Fish, who's here, and David F. Solomon, who's also here. His paper is, I think, unique in that, well, before I talk about his paper, he does have, and it was mentioned yesterday, he has either been, I guess, an objector or supported objectors to various settlements in Delaware litigation, and that's an interesting thing. I think his paper is unique in that he sort of presents an entirely different approach. Most of yesterday's conference and today's conference, I think, is focusing on is Delaware going to stay the leader, and is there another state that might overtake it, or might the federal government overtake it? Well, he presents a totally different idea, which is maybe we look across the Atlantic and look at the Anglo-Irish model of regulation. I found this interesting because actually in my prior life, I was the Commissioner of Corporations for the state of California, so I was an administrator and had a role in the California administrative state. And we do have, it's gone away largely, but we used to have more of an impact through the blue sky law on corporate governance, but with federal preemption, that's largely disappeared. So, Professor Griffin, thank you for that. I'm going to sit here so I can look at you. Okay.
Okay, thank you, Keith, for that introduction, and thanks for having me out. And it's a pleasure to be here among friends and among people whose work, both among practitioners and the academics who I've followed and respected for a long time. This presentation is an abbreviation of a larger work that I'm working on with Dan Alray, who is at Oxford, and Blaine Clark, who is at Trinity College Dublin, and on the Irish takeover panel. And so here it goes. We have a crisis in corporate law. And the crisis in corporate law is a crisis in shareholder litigation, exemplified principally by the path of merger litigation. And everyone in the room knows this. These cases get filed as Revlon claims against every deal, alleging defects in process and price, but then they get settled for worthless disclosures. It's not a blip, I think, as Bob suggested yesterday. It's persistent since 2009. It's gone down to a number in the 70s instead of a number in the 90s, but the historical amount of shareholder litigation for M&As is a number like a quarter to a third, so we're still well above the historical average. And it's not going away, it's just going to other states and other jurisdictions, as we said. I understand the argument in the room yesterday about how if we advise boards of directors, we want to tell them that maybe this type of litigation is useful. Because after all, from the board's perspective, you get on with your transaction and there's no risk of liability because of the intergalactic release that you get in connection with the settlement. From the shareholder perspective, it's not good. It's not good because shareholders are made to waive potentially real claims for no real relief, and they pay for the privilege. But the worst part about the system is the pernicious incentives that it sets up on both sides of the V. And the process really becomes a pantomime, where as soon as the plaintiffs file the preliminary motion for a preliminary injunction and the motion to expedite, they get access to very little, to the board books usually, but then magically disclosures appear prior to the shareholder vote. There's a period of confirmatory discovery where 2 or 3 depositions are taken in a non-adversarial context. They get a couple of 100 pages of documents and the talismanic phrase, some emails, and the case gets settled and goes away, and the shareholder rights, substantive rights for any and all underlying facts, litigation related to any and all underlying facts goes away. That's a problem. That's not real litigation. It's non-adversarial. And there's no reason, as a result, there's no reason to believe that it smokes out the bad stuff that could be in these transactions. Now, probably for a lot of these transactions, there's no bad stuff. But, I'm told, well, probably for some of them there is, and we just have no way of knowing. We have no confidence in the system at getting them. So the system doesn't seem like it's really doing anything. And that's bad for shareholders, and it's bad for Delaware. It's bad for Delaware because Delaware is a system premised on regulation by litigation. And if litigation isn't working, the regulation isn't working. And it makes the whole thing and the whole system seem like a sham and somewhat corrupt. It looks like rent-seeking from attorneys rather than protection of shareholder rights. Now, I'm not the first person to notice this. The judiciary noticed it long before me and tried to solve it in a number of different ways. First of all, by cutting plaintiffs' fees for settlements of disclosure settlements. That didn't work because we know from crack cocaine that if you lower the price of the addictive substance, you just stroke the addiction, and so that led to more disclosure settlements because they were cheaper from the defense perspective. ATP, the judiciary tried to solve this with the ATP versus Deutscher Tennisbund. Didn't work because the legislature/bar immediately overturned the judiciary. The judiciary tried to solve it with Trulia. Trulia is not working. It's not working because the cases, it looks like, are going to other states or the federal system. And as Steve said yesterday, Steve Davidoff said, the judiciary is also trying to reform it by to address the problem by reforming the substantive standards. And he had a long presentation about how the substantive standards have been changing, and with numerous case citations. I think that's true, but I think that's actually also pernicious because that's throwing the baby out with the bathwater, right? These substantive standards are designed to enable real litigation in real cases. And what do we have? We have the tail wagging the dog. These not real cases are causing the judiciary to change the substantive standards that are supposed to guide real cases and therefore make real cases harder to bring. So the entire system of regulation by litigation seems corrupt, and we see that in the context of merger cases. And so the question that we ask, that the symposium has us asking is, can that crisis, or that sort of crisis, lead to the dethroning of Delaware? Now, this has happened before. So this is a cartoon from Punch magazine from the early 20th century. It's about New Jersey. So you can see New York City on the other side of the Hudson River, and all these criminals coming across the Hudson to New Jersey. And the caption at the bottom says, "The big ones go to Jersey." That would be the two guys in top hats who are high finance and corporations. And why can't the little ones go to Jersey too? What are they going to Jersey to do to incorporate? That didn't last long, as we said yesterday, because Woodrow Wilson came along and solved/created a problem for New Jersey. And so we know from history that you can dethrone a market leader in the market for corporations. And the question, I guess, is, well, is there anything is Delaware at risk by this sort of corruption in its system of regulation by litigation? Is there any reason to believe that another state could eat Delaware's lunch like Delaware ate New Jersey's? And I say that with some grief because I'm a citizen taxpayer in the state of New Jersey. So there are a number of obstacles to the interstate market for corporate law. These were discussed yesterday also, so I'm just going to touch on them. There are network effects. There are switching costs. Bob Thompson was talking about lock-in yesterday, so that the incentives of Delaware raising so much revenue from the franchise tax binds Delaware to not doing what Woodrow Wilson did in the early 20th century. And those are all true, but look, they don't prove that there's no competition. In fact, the Hellsworth proves that there is competition, and the Nevada issue is a proof of competition. One of the points that we should emphasize about Delaware, one of the advantages of Delaware, or the strengths of Delaware, and market protective advantages that it has, is its judiciary. And this came up a little bit yesterday, but not as much as it could have. Delaware regulation is regulation by litigation. So when you have regulation by litigation, you need to have really good judges, and Delaware is blessed in that. And the judges are applying flexible standards. Now, the good thing to say about flexible standards is that they can accommodate all kinds of problems that come up. The other way to describe flexible standards is as largely indeterminate and litigation provoking. And maybe most importantly from the perspective of the interstate race, they're hard to copy. They're hard to copy because so much depends upon the discretion of the judiciary. And as Greg Williams asked yesterday, if your client wanted to go to another state and you asked them, and they asked you, would you trust the judges in another state? And the answer to that, we all agree, is no. So, is there a way to compete with Delaware that, does the judicial advantage that Delaware has mean it's impervious to competition? And I think the answer to that is no. But the only way that this could possibly happen is by imagining a regulatory system that doesn't depend on litigation or judges. That is not regulation by litigation, but that is regulation by regulation. Could we imagine such an alternative? Well, we don't have to imagine it because it already exists on the other side of the Atlantic Ocean. There are lots, so of all the countries in the world, the country that is most like us with regard to market transactions, with regard to corporate law is the United Kingdom. And the United Kingdom has lots of M&A, and the way that they do M&A is totally different from the way that we do M&A regulation. Now, I'm not talking about their substantive rules. Lots of people have written about the substantive rules, in particular about how the UK takeover panel does not allow takeover defense, for example, in the same way that we do. I'm not talking about the substantive rules. I'm just talking about process. So how do the British and the Irish regulate mergers and acquisitions? And they have two ways, and they're very different from ours. One is there's a panel. And what the panel does, first of all, who is the panel? The panel are experts drawn from a wide constituency base. Not just the bar, not just the judiciary. A wide constituency base includes institutional investors, corporate managers, bankers, lawyers, folks like that. They sit on these panels. What does a panel do? It applies a detailed code, the city code in the case of the British, the Irish rules in the case of the Irish. And those codes are ex-ante regulation of process and disclosures. Now, so the deal process is written out in great detail, and most importantly, perhaps, the disclosures are. Now, we also have that in our SEC rules with regard to the disclosures, but that's an aside. In addition to the panel, ex-ante panel regulation for process and disclosures, the British system relies upon, it enables ex post litigation. So it's not a complete substitute to ex post litigation, but there's a complementarity. And the way it works is, well, you've got a lot of ex ante protections in the British system, so you don't need as much ex post protection in the form of litigation. So there's controls in the UK system, and those include fee shifting, which we were talking about yesterday, and they also have rule of barring class actions. So there is a litigation remedy in the event that shareholders are defrauded, but it is not the kind of litigation remedy we offer, and this makes some sense, right? The British system can be a bit more strict ex post because they have some shareholder protections ex ante. Now, this is all interesting, and it's cheap, and I have some evidence, not great evidence, that it's quite a bit cheaper. The cost of administering the panel per deal is something, well, it's a fraction of the amount that plaintiffs recover in a disclosure release. We can talk about the relative merits of the system on the Q&A if you want, but the question for me is, why haven't we even tried this in the United States? It seems like this model's been around in the UK for since the 60s and 70s, and it's an obvious alternative. We have, Brandeis or Cardozo said, 50 laboratories of democracy in the United States, but none of our 50 laboratories of democracy have attempted this other system. Instead, every other state, to my knowledge, does regulation by litigation just like Delaware, but less well. So the question is, why hasn't anyone tried this in the U.S. system? And I just come back to the Macy and Miller hypothesis about the bar. It seems like if reforming regulation by litigation means killing the ability of the bar to extract rents from the process, it's the goose that lays the golden egg. And so the bar is central in reform. We were talking about yesterday the role of the council in adopting reforms in Delaware. That was illustrated beautifully by the ATP story and the immediate 2-week later reaction of the council to the risk that it was going to destroy their livelihood. It was glossed over that the memo that the bar came back with, there was a grand bargain in the sense that there were 2 rules that came back a year later. But the memo, the actual text of the anti-fee shifting rule was exactly the same as it had been. And in the memo that the Delaware Council drafted defending the choice to maintain the anti-fee shifting rule, there was no discussion of the fee shifting literature, which there's a deep literature about the effects of fee shifting in academia ignored. So it seems like it wasn't a real process to get rid of the rule. And it seems like that it seems very difficult, not just in Delaware, but in other places, to loosen the regulatory model from the stranglehold bar. It's also difficult in Nevada. Now, Nevada offers a different set of rules from Delaware, but Nevada is still regulation by litigation. And post-Trulia, I came across an article by a Nevada practitioner, post-Trulia, pounding his chest about how easy it is to get disclosure-only settlements approved in Nevada. Now, if Nevada was really about eliminating litigation, you wouldn't have a proud practitioner about the ability to get disclosure-only settlements in Nevada. You would have some kind of a rule that made it impossible to bring those kinds of non-regulatory suits in the first place. It strikes me that the centrality of the bar across states suggests that a regime built on regulation by litigation is not going to change as long as the bar holds the doorway to corporate law reform. We're unlikely to see a movement away from a litigation-centric regulatory model, which might be a sad state.
Thank you. Our next presenter is Michal Barzuza, who comes to us from the University of Virginia. She has her law degree from Tel Aviv University, and she has a couple of degrees from Harvard Law School. I had to Google one. That was the SJD, which, according to Google, is Harvard's law school's most advanced degree. So that's very impressive. I'm really excited to finally meet Nicole, because over the years we've corresponded by email about various Nevada corporate law issues, and she's been a leader, I think, in writing about Nevada and Nevada's role in sort of the 50-state competition for corporate charters. One of her papers in 2012 was selected as one of the top 10 papers in corporate securities law. It was on Nevada. She, in her presentation today, looks at what we know about Nevada so far, and addresses the issue also, which was mentioned a little bit yesterday, about whether Nevada corporations underperform versus their peers. So, thank you.
Thank you so much for this introduction, and it's a great pleasure to be here. Thank you, Steve, and especially for the opportunity to finally meet Keith. Some of it, so as Keith said, I'm going to talk about what we know and what we don't know yet.
Probably just to the desktop.
That's right. And first I want to stress the doctrinal part. Again, this will not cover all the differences, but it will cover the main ones. Some of them will repeat what was already in the 2012 piece, but I'd like to repeat that. Kit has a great book about Nevada law, so you can read more there. So we all worked under the assumption that Nevada copies Delaware law. There were different versions to this assumption. One version even suggested that Nevada is committed to adopt the future cases of Delaware law, and so forth and so forth. When I started seeing differences between Delaware and Nevada law, that surprised me. I kind of continued to look into that, and I continued to see more differences, and then even more surprised me. So I was trying to see where this assumption was coming from, and everyone was referring to, the oldest reference was to the famous paper by William Carey that was published in the Yale Law Journal. But if you go to this paper, all Carey said really was this sentence, which is Nevada has attempted to become the Western Delaware. So somehow from this reference, I developed an assumption that Nevada copies Delaware law. But apparently already in 1987, and that's important because our paper and other ones kind of focused on the 2001 amendment, But the 2001 amendment, all it did was to make the default law mandatory. The default law was already different from Delaware. So the Nevada 1987 exculpation statute that was adopted 2 years after Delaware wanted to be severed was already different from Delaware exculpation statute in two respects. One is that it protected officers in addition to directors, and Delaware statute protected only directors. And second is that while Delaware statute included, all the exceptions to the exculpation, the duty of loyalty, the duty of good faith, and the prohibition on improper personal benefits, the Nevada exculpation statute already then included only one exception, which is the intentional misconduct, fraud, or non-violation. Okay? Now, yes?
If you go to the middle at the top of the screen, you'll be able to run the slideshow. At the top,
Right.
now to the right, go across the middle, you see where it says slideshow,
Yes, thank you.
and that'll stop that other thing that I'm popping up.
Yes, thanks. So, so already the exculpation statutes of 1987 included only this exception. And proximity laws from pre-2001 interpret this exception to mean exactly what the Secretary of State's website now and others say about Nevada law, which is the difference between Delaware and Nevada corporate law is that in Delaware you are liable for breach of duty of loyalty, whereas in Nevada it's only if there's also, in addition to that, intentional misconduct, fraud, or non-violation. Okay, so already then the understanding was that in Nevada you can opt or opt out of duty of loyalty except for acts that amount to intentional misconduct, fraud, or non-violation. Then the 2001 amendment took the exculpation statute and made it mandatory, applied to all. In 2003, that was changed to an opt-out default, so it applies by default, and also was extended to protect directors and officers from creditors' lawsuits. Okay? So as a result, today in Nevada, by default, directors and officers not liable for shareholders and creditors for breach of duty of loyalty or duty of good faith, unless there is also intentional misconduct, fraud, or non-violation of law. And the burden of proving exculpation relies on the plaintiff. The question, of course, is how is this applied by courts? And the problem is that we do not have a lot of cases because the Nevada courts do not publish their cases. So the cases that we have are all federal courts. So, for example, here's a recent case that asked the questions of whether directors have conducted a non-violation of law. The directors knew that the CEO took a margin loan on the company's stock, but they did not disclose it in the company's financials, even though there is an obligation to disclose that. The court decided that following the intention, the legislative intent to provide broad protection to directors and officers, the non-violation of law exception should be interpreted to apply only if the directors also knew that this is prohibited by law. So here's another difference in Delaware. While in Delaware, a non-violation of law requires only that you knew what you did. It doesn't matter if you knew that that's prohibited or not by law. In Nevada, according to the 10th Circuit, you also have to know that this was prohibited by law. And here it was not proven that the knew that that was prohibited. And the court says without the board members are expected to know the immunity of the SEC regulation, and directors were found not liable. So while we cannot, know exactly how this is going to be applied by each board, I think there's a kind of a consistent legislative intent to provide more protection to directors and officers. And this is also reflected in the Nevada Secretary of State website that kind of explains all of these differences as reasons to incorporate in Nevada, again, including the differences with respect to duty of loyalty, directors and officers, where the default is, the burden of proof, and so forth. Questions so far? Yes, Dick.
So, we've been going back and forth on this for about 4 or 5 years now. And so every time you give this presentation, I mean, these laws are great, but I think a couple things. So one, I've done expert witness testimony in Nevada, right, whatever you call it. And people, it unfolds exactly like Delaware litigation. They cite the same cases, they do the same things, it ends up in the same settlements,
Are you talking about takeover?
Yes, I'm trying not to take over law.
Right.
So that's number one. Number two is, if you look at Delaware, and this is the Black Klausner piece, I mean, no one's held liable in Delaware personally as directors and officers, and you're more liable to be hit by lightning than be held liable. And then three, so I know on the books the law looks different, but I think in practice it might be different than what you're saying. And certainly different companies are going to Nevada, and certainly that's an effect. I'm not questioning your paper, but I just wonder how much this law in the books matters. And I think finally, if the cases aren't really published, you can look at it, because again, merger litigation, which I have statistics going back to 2003, merger litigation in Nevada does not look any different than merger litigation in Delaware. You have big settlements, same law firms. Randy's happy to bring Nevada cases all day long. And so I just wonder if, in effect, this really all matters.
Oh, great. So,
And I've asked you this before.
No. I think these are all great points,
Yeah.
But I think I have answers with several levels. First, we don't know, and also the corporations that are going there don't know, right? Because they don't have the cases. So what they know is what the law is, and this is also what they explain in their proxy materials. And what they know also is what the legislative intent is and what the political environment is. So you're kind of opting into something that you have lots of unknown about, but at least the intended is like being represented outside, and the marketing is suggesting more protection. Okay. Second, I think that the takeover law is a different. I think that the duty of loyalty differences are more important than the takeover law differences. And this is related to more research that should be done into Nevada companies, because I think that the ownership there is more concentrated. So there are more companies with concentrated ownership. Now, having said that, there was also an issue with the takeover case, right? So the Hilton Hotel case that many of us teached in, where in a dicta, the judge said Nevada follows Delaware Unicorn and Blasius. Nevada legislature stepped in and responded to that by changing the law, right? And replaced it saying, we apply this as judgment to Unical and regular circumstances. And we apply Unical to Blasius circumstances. And the legislative history says the case might be wrongly interpreted to suggest that Nevada follows Delaware standards, but it does not. We want to provide this judgment. Even though you can see Unical and Referral are not that significant anymore, right? Which is completely fine. I'm just saying, when we look at this whole package, there's a kind of clear message they're trying to send.
Let me jump in and remind everybody that what we're trying to do is to keep the presentations to about 15 minutes.
Oh, okay.
And let me remind everybody that we're trying to keep questions until after all three panelists have had an opportunity to make their presentation, so that the presentation doesn't become the first presentation doesn't become the entire panel, period. So if you could wrap up and we could move on to the next panelist.
Sure. So I'll say one more thing related to the one to Sean's point, which is, I think that once you have one exception, which is intentional misconduct for the non-violation of law, it's much clearer and it needs less judicial discretion and less than the fiduciary duties. So in a way, Nevada alternative is also kind of evading the Delaware advantage by offering a clear law. So, and I'm sure Keith will have more things to say about the differences with the law. With respect to Nevada companies, I think that our study looked at reporting behavior, found very high frequency of accounting statements in Nevada relative to other states and to Delaware. We can talk later about what accounting statement. We also find that Nevada companies are ranked as very aggressive in reporting in general, according to a rating of reporting behavior. We employed several methods. We can talk about it. Now there are other studies that look at international companies that reincorporate and also that do cross mergers and also find aggressive restatements and behavior of Nevada companies. There's a line of studies by forensic accountants that finds that Nevada companies occupy the SEC enforcement actions and so forth. So I think that with respect to the reporting behavior, the evidence suggests that they are different, they are more aggressive in the reporting. With respect to their, we also found, and Nevada also found that they are smaller, they have less institutional holdings. And of course the question is how that affects the performance of Nevada companies. Here we found, even though we are frequently cited as we suggested Nevada companies suffer from a discount, we found that there's no discount to incorporated in Nevada. Some suggested there was even premium to incorporate in Nevada or just for small companies. For the 2001 effect, there are different results. For the reincorporation effect, for a subgroup of companies, there is a positive result, but there's a lot of missing data. I'll close by saying, and this is a stress of what we don't know, in interpreting the Tobin's Q results, I think we face lots of challenges, and for this reason also our study did not focus on Tobin's Q. The Nevada companies are really small, so the measurement error is more problematic. The high restatements could affect the value. There's a very high rate of firms that exit the CompuStat database, so there's a high rate of companies shutting down, so that could cause a survivorship bias. They are traded mostly on OTC, so there's a lot of data missing, so the studies are using like different methods to complete these missing days, but these days are missing. There's the issue of course, learning by the markets. And there's the issue of Nevada's marketing strategy, which I'm not sure, maybe Keith knows better, when they exactly started to aggressively market their package, which also should affect the market value, and none of the studies have like this type. Thank you.
Thanks. We face the dictatorship of the clock here for all these interesting topics. Our next presenter is Joe Fish, who comes from the University of Pennsylvania. She earned her JD at Yale Law School. She has written, as I'm sure everybody here knows, extensively on corporate securities law issues, most recently about topics like majority voting, insider trading in Salmon, the recent Salmon case, and litigation bylaws. Her paper looks at the contractual, sort of the tension that exists between the contractual approach to corporate law and bylaws and to the director primacy and the authority of the board and what's going on there and what this means for Delaware.
Okay, so thank you, Stephen and others from UCLA for the opportunity to be here and for the chance to be part of this great conference. You really assembled a fantastic group of participants and papers. And apologies, this paper doesn't fit very well with Sean and Michal's papers. And really sort of goes a little bit better with the discussion yesterday. I'm not really focused in this paper on regulatory competition or alternatives to Delaware law. So, cabin that off in your mind for, at least the next 15 minutes. I don't know exactly how to navigate the Q&A. But think back to the discussion yesterday and sort of explanations or theories about Delaware's dominance and why that's the case. We focused a lot in our discussion yesterday on this indeterminacy of Delaware law and on the expertise of Delaware judges in kind of navigating that indeterminacy. But Delaware law has also been defended because of the sort of enabling approach, the flexibility that it provides to different types of firms to structure their internal affairs, to structure the balance of power between shareholders and directors. And it's that aspect of Delaware law that I want to talk about for a few minutes today. The enabling approach to Delaware law, I think, fits in very well, and it's kind of hard to say kind of which theory came first, but it fits in with this theory of the contractual nature of the firm, which, depending on what literature you're looking at, if you're looking at the economics literature, right, this kind of started in the 1970s. If you're looking at the law literature or the law and economics literature, it's really the late 1980s, early 1990s. But the basic idea is that a firm is a nexus of contracts, this sort of enabling approach is desirable, that it's efficient because it allows firm-specific specialization. One size doesn't fit all, and we have all sorts of markets that can discipline firms that make bad choices, right? Like the stock market, like the market for corporate control, like the product market. Easterbrook and Fischel obviously talk a lot about this market-based approach. And finally, if we have a mandatory approach, there's a possibility of regulatory error. So this paper fits in with this contractual theory of the firm, right? And this has become very popular as a, not just a descriptive view of the firm, but as a normative view. This is what the firm should be. You see this in the academic literature, but you see this increasingly in regulatory debates as well. So if you think, for example, back to a few years ago when everyone was debating about proxy access and the provision in Dodd-Frank and the SEC's rule 14a11, right? There's this big debate about, well, okay, should we have a proxy access rule that's part of federal law, in which the federal government, the SEC, decides what the standard is for proxy access, and all firms have to implement this, or should this be something that's addressed through private ordering? And obviously, with respect to proxy access, private ordering won out. But this approach to corporate governance extends well beyond proxy access, right? We see, and I've written I've used the term the new governance to describe this approach to private ordering in a range of different areas. Proxy access and majority voting are one, things like advance notice bylaws, and obviously issues like litigation bylaws, fee shifting, forum selection, arbitration bylaws, right? They all fit within that general category. So you see how this really fits in with yesterday as well. Now, when we talk about private ordering, there are choices in how we do it. One big choice is between between the charter and the bylaws, and I'm going to put that issue aside. I think it's interesting and important. That's not really the subject of this kind of modest paper today. This paper today focuses on doing this through the bylaws, and in fact, we see the great majority of private ordering efforts affected through bylaw provisions. Board-adopted bylaws on the one hand, shareholder-adopted bylaws on the other. Obviously, they deal with separate issues. Sometimes the board gets out in front of something and adopts its own bylaw in an issue that's typically a subject of a shareholder-adopted bylaw. We see this with respect to majority voting. But I'm focusing on bylaw provisions, right? And as I say, this has really emerged as a hot area. Dramatic growth in just this year in shareholder proposals seeking to adopt proxy access bylaws. So that's the general subject that I'm looking at. Now, how should Delaware law, and in particular, how should Delaware law courts respond to the new governance, to the emergence of these corporate governance bylaws? Should the courts be apply some sort of careful scrutiny, or should the courts be largely deferential, taking into account all of these benefits of private ordering that I've been talking about? Well, in the Boilermakers case, our good friend Leo Strine says, well, that contractual theory of the firm, that informs the court's approach. Basically, the bylaws are part of this contract. This contract between or among the directors, the shareholders, I don't know if the executives kind of buy into this contract as well, but this is a corporate contract, and the statutory framework of the Delaware corporate law, right, respects that, right? And as a result, because it's a contractual approach, we, as judges, we stay pretty laid back. We presume that the bylaws, at least board-adopted bylaws, right, caveat, I'll get to that more in a minute, we assume the bylaws are going to be valid, right? And the basis, Justice Strine, at that time, Chancellor Strine, the basis for this contract analogy is one, implied consent. When shareholders buy into a corporation, they know that the directors can amend and adopt the bylaws. They know they can do this, right? And there's the language on that, which you don't have to read. And two, shareholders have the capacity to change it. If shareholders don't like the terms, they can amend the bylaws, they can adopt their own bylaws, right? There's this interaction, there's the opportunity of a shareholder fix, right? And that's the language where Justice Strine says that, right? So I'm going to focus for just a minute on the second of these. Put aside, again, the issue of implied consent. I know I'm requiring you to put everything aside, right? Competition and charters, and now you're putting aside implied consent. That's very narrow paper. All right, so think about just this one thing. Shareholder power to reject objectionable contract terms. I want you to think about that a little bit more carefully. Because I don't think, at least under current Delaware law, this provision or this basis for a deferential approach to board-adopted bylaws carries quite as much weight as Justice Strine claims it does. Right? I don't think the contract analogy quite holds up. Why not? Well, first of all, board power under Delaware law to adopt corporate bylaws is extremely broad. But shareholder power is not. It's not a level playing field. And as a result, the contract analogy is flawed. Right? What do I mean? Well, constraint number one is the Ascani case, right? And now we need a different picture. Justice Jacobs instead of Justice Strine, right? Justice Jacobs says, well, when it's a shareholder-adopted bylaw, there's this limitation in the Delaware statute, Section 141A, which gives the board the authority to run the corporation, limits what shareholders can do through a shareholder-adopted bylaw. Now, Ascami is a controversial case. People have debated exactly what its limits are, or what the best way is to understand the case. But this is, still, and it's been cited subsequently, right? This is still a fundamental principle of Delaware law that shareholder power to adopt and amend the bylaws is not unlimited, right? Constraint number 2. That's a crowded slide, not very well done. I've only got 15 minutes, which I've probably already run through. There's a whole bunch of other stuff. If you want more details on the other stuff, you can of course look at the paper. But let me just suggest a couple of possibilities. One, the Delaware statute is written in a way that expressly authorizes shareholders to adopt certain bylaws. Shareholders can adopt a proxy access bylaw. It says that clearly in the statute. Shareholders can adopt a bylaw that provides for reimbursement of proxy expenses. Well, does that mean that that express articulation is some sort of implicit limit? Can shareholders only adopt bylaws in situations where the statute permits it? Otherwise, what's the point in having those sections in the Delaware statute? If we look a little bit beyond Delaware, we find even more express limits. In some states, there are limitations. There are some things shareholders can't do through the bylaws. For example, when we were writing our majority voting paper, we looked around outside of Delaware and found in some states, shareholders don't have the power to adopt a majority voting bylaw, right? So, not the same level of authority. There's also a question, well, how exactly does the board power to adopt and amend bylaws interact with the shareholder power? If the shareholders have the power to adopt a bylaw, can the board just undo it? In Delaware, it appears that that's the case. In Model Act states, of course, the Model Act provides that if shareholders adopt a bylaw, they can preclude the board from changing it. That doesn't seem to be true in Delaware, and the case law is at least ambiguous on that question. And what about a board-adopted bylaw pursuant to its power under 141A? Presumably, that same limit in FSCAMI that says, okay, this is a business issue, this is not something the shareholders are allowed to touch, that would prevent shareholders from initiating a provision through a bylaw, would also prevent the shareholders from amending something that the board of directors has done. So a number of concerns, I've run through them very quickly, but I'm already down to my last 3 minutes. If those legal constraints don't particularly worry you, there are practical constraints as well, collective action problems, supermajority requirements, vote counting rules, and of course the role of the SEC, including the fact that when the shareholders try to adopt a bylaw, the SEC has to decide, is this bylaw within the scope of the shareholder's authority? And if the SEC decides that it is, based on a learned opinion by Delaware counsel, the SEC may decide, okay, the company can exclude it, this issue never even gets before the shareholders for a vote, right? So then you have to worry, if the shareholders can't get it on the agenda, how exactly do these checks and balances that Justice Strachan is relying on, how do they work in practice? Okay, so there are two potential responses to these concerns. And you might say, okay, well, there's all this other stuff going on, right? Proxy advisors and the SEC can always certify this. And yes, I will grant you, all of that is the case. I don't think that quite gets us to a level playing field. So there are two ways that we could come at it. We could say, okay, let's just raise shareholder power. And there have been a number of articles that have argued for different ways to do that, right? Let's just make it a meaningful contract in the way that Justice Strachan has in mind. We can overrule FSCAMI. We can have a statute that explicitly grants shareholders coextensive bylaw authority with the board. We can adopt the Model Act's protection of shareholder adopted bylaws, right? Lots of different approaches. But there are problems with this. And here, since of course Steve Bainbridge is our host, right, I want to focus on one of these problems, and that is, if we equalize shareholder power, as some people have argued we should, we're going to run into a limitation or a potential interference with the kind of board-centered model of corporate governance that is also a hallmark of Delaware law, right? Enabling approach, indeterminacy, all of those things are great, but also centralizing authority in the board of directors, that's really a critical feature of Delaware law. So I don't think we want to run too fast to adopt option 1. Right? So option 2, the alternative, is what I advocate in this paper. And you actually don't have the drafting, which is completely spelled out, but I'll send it to you. Option 2, what I suggest is that instead of raising shareholder power, we give the board a little more expansive authority to review new governance provisions that are adopted unilaterally by the board. And here I propose something that draws from the analysis in UNICAL, right? The board adoption of a bylaw that limits or interferes with shareholder rights, because shareholders don't have free opportunity to override it, should get a little higher level of scrutiny, right? And the advantage of this approach is that it preserves director primacy, and it's also not as heavy-handed as the board saying, oh, we're going to keep hands off, and then the legislature having to come and step in, as it did with the 2015 amendments, and say, gee, on this subject, loser pay bylaws, we have to abandon this completely. We can't have that kind of nuanced approach that we've come to love about Delaware law. So, example, I'm on borrowed time here, but 30-second example, and in the Q&A I'm happy to talk about how this approach works in other areas. Easy example, form selection bylaws, right? Form selection bylaws arguably limit shareholder power. They prevent shareholders from filing a lawsuit in whatever state they would like, right? So I argue the court should apply heightened scrutiny. Is there a problem? Well, yes, the problem is multi-forum litigation. Stephen and Sean and any number of others have told us about that. Is the response appropriate? Is the response proportionate? Well, yes, it is. It doesn't preclude shareholders from suing altogether. It's narrowly tailored. It responds specifically to the problem of multiple lawsuits, and it doesn't insulate the board with respect to accountability. Right? And here I'm drawing not just on UNICAL, but on some of the analysis in Blasius, and suggesting that the key area in which we should be suspicious, in which we should scrutinize board-adopted bylaws carefully, is where they limit shareholders' ability to hold boards accountable through their right to elect directors. So obviously, the analysis is going to come out differently if we talked about advance notice bylaws or something like that, which we're not going to. So there's the conclusion, but I don't have time to say it, and I am done.
So thank you. Just as observation, the difference, a real difference between Delaware, California, and Nevada. In Delaware, the certificate of incorporation can empower the board to make the bylaws. And in California, the articles of incorporation can disempower the board to make bylaws, take away that power. In Nevada, the articles of incorporation can take away the power to make bylaws from the shareholders. So you see a real difference among those three states. Our final panelist today is Lynn Lopucky, who's UCLA. I thought it was interesting. He's the Security Pacific Bank Distinguished Scholar. And I thought that was interesting because I remember the Security Pacific Bank. And it lives on, I guess, in the name of your chair. So, and it also sort of fits with one particular line of your paper, which is California being the biggest loser. California used to be the home, sort of the west coast of the banking industry, and Security Pacific was one of the big banks out here. It was acquired by Bank of America, which is now in North Carolina. So we've lost a lot of our financial services headquarters here as well. He got his JD from Michigan. He's co-authored a casebook on secure transactions and also commercial transactions. His paper looks at a system strategic analysis to explore Delaware's role, and he has, I think, a real sort of toxin that he's sounding here, that Delaware faces a kind of options choice. Does it keep feeding the plaintiff bulldog by rewarding them with fees, or does it keep feeding the corporate bulldog by encouraging them to choose Delaware as their home? And between these two bulldogs is there this other lurking problem of arbitration.
Okay, I'm going to talk about the charter competition. This is a paper that uses systems analysis in order to address these two questions. How does the charter competitions system work, and what does it do? What's its objectives? The literature here is just a gigantic literature. It's reflected in a gigantic paper, and I can't present the whole thing. So what I'm going to do is hit on the 5 points where I think it is most changing the conventional wisdom. The first is the idea that the courts are the delivery system for all states, corporations, laws. They are the regulators. Secondly, Delaware is dependent on a judicial strategy. And because it's dependent on a judicial strategy, it's at very high risk. Third, aside from, you put litigation aside, states don't really need any expertise in corporate law to compete for corporations. Fourth, this charter competition is insulated from democratic control. And lastly, the charter competition is multi-directional. It is not just Delaware against the home state, as much of the literature insists. So start with this product of the systems analysis, and let me get up here where I can point at it. There are 3 subsystems at work here. The first one is the system by which the corporations are choosing their states of incorporation. Those things are happening in different forums from the rest of this. The second is the states preparing their packages to offer to the corporations. And in preparing those packages, they're deciding things like what kind of courts are we going to have, who are we going to empower to sue in those courts, the allocation really of the power to the courts. And then ultimately it is the courts that are doing the regulating in the third of the subsystems here. Now, the key point from this is that Delaware is the only one that has control of the regulation system. The rest of the states, it's gone off into maybe judges of their own state, maybe judges of other states, judges, federal judges, but the state's not controlling it directly the way that Delaware is. Now, Delaware, as a number of you have already noted, has a great court system. It's a court system that can't be copied. High volume of case flow that nobody else has, enables specialization, enables expertise, and then there's the Delaware's speed with which they can grant hearings and with which they can dispose of cases. Their pretty much unique freedom from jury trials, and the loyalty of the judges who are administering corporate law. Delaware has a corporation law that isn't worth copying. It is verbose. It is, in word count, it is twice the size of the Nevada corporation law. It is redundant. There's a professor at Harvard, Olger Spaman, who is going through the Delaware corporation law and simply eliminating redundancies. And he claims, and I've looked at what he's doing, and I think he's actually doing it. He's pulling out maybe a third of the words out of the code without changing the meaning at all. And Delaware corporation law is badly formatted. I don't know why corporation people don't seem to notice that their statute looks different from every other statute. That other statutes are paragraphed in order to make them easy to read. In Delaware, it's just a big block of text. There's a huge literature on the indeterminacy of Delaware law. And I want to point out here, because I don't think Delaware people really appreciate this point, indeterminate's the opposite of predictable. And yesterday people were saying, we want predictability in corporate law. And that's why Delaware is so great. And then they're also saying, yeah, Delaware law is indeterminate in so many ways. Now, thirdly, the Delaware corporation law it controls nothing of importance. If it says you can't do something, doesn't mean you can't do it. If it says you can do something, if it says you can't do something, you can't do it. Sorry, okay. If it says you can do something, it doesn't mean you can do it. And if it says you can't do something, it doesn't mean that you can't do it. And those are just the case citations for those two propositions. So what's going on here, the judicial strategy, is that Delaware is making its law on a case-by-case basis. Think of it as there really is no statute. There's simply the courts. And what they're doing is favoring managers. They're the customers. The competition forces Delaware to favor the managers. And they're trying to do it without appearing to favor the managers. And that's because the maintenance of legitimacy is a major consideration in this system. And secondly, the judges on the spot administering the law are protecting Delaware's reputation. Now, all of this judicial strategy requires cases. And that's where the risk comes from. There's the Armor Black article, Delaware losing its cases, surveying since 2001, that the plaintiff's attorneys, you're not giving them the fees that they want, so they're not coming to Delaware any longer. And Delaware's solution is forum selection bylaws. We will make them come to Delaware. And then APT Tour offers the means to cut back on shareholder litigation. And Delaware's solution is we don't want to cut back on shareholder litigation, at least not right now. We're going to see what happens with this. Trulia, this is where Delaware discovers that managers don't want good judges. Managers want to win their cases. And I think just reading the opinion of Trulia, it had to have come to even though the judge acknowledges the possibility the cases are going to go out elsewhere, it has to come as a big surprise that the cases really did go elsewhere. So the solution is to be announced. And while Delaware is reeling from these things, along comes arbitration. Arbitration is the means to eliminate class status and fee awards, everything that drives shareholder litigation. It's capable of wiping out shareholder litigation, not just moving it to arbitration, but causing it simply not to be brought because there are no longer any attorney's fees for bringing it. Delaware anticipated this, in my view. They had the statute that attempted to create secret arbitration by the Chancery Court judges, and that was cut down by the Third Circuit. The current strategy is to prohibit arbitration bylaws. If you read Section 115, it really does. It says you can't go to any other forum, and that would include arbitration. But of course, they can't do that because federal law prevents them from doing it. Delaware is positioning itself with regard to the arbitration problem with the Delaware Rapid Arbitration Act This is offering arbitration by Delaware lawyers. Think of it as, we couldn't do this secret arbitration with the chancellors, but we can do secret arbitration with the lawyers. But that law doesn't extend to arbitration bylaws, which I take the meaning to be that Delaware doesn't want to throw the first rock here. They're just positioning themselves for when that rock is thrown. So, arbitration is capable of eliminating nearly all shareholder litigation. It's capable of killing Delaware's judicial strategy. Now, what happens if the judicial strategy goes? Where does that leave Delaware? The old concept was that corporate law was about striking the right balance between the interests of managers and shareholders. That's what the Kerry-Winter exchange was about. And lots of people here saying that corporate law is all about this balance. So if it is about the balance, then the state is the one that has to have the expertise to strike the balance. The new concept that I'm proposing here is that the way you should be viewing this is that the states are really giving all the power to managers. The managers draft the certificate and the bylaws. They can put anything they want into the certificate and the bylaws before they've got any shareholders. They do have to negotiate with the shareholders, but they need to cede only as much as the shareholders insist on having. So there's no need for any balance to be struck by the state, but rather private ordering can strike that balance. The state doesn't have to have the expertise. Now, just to illustrate my point here, I drafted a Model Corporation Act of my own. It fits on this slide. It has room left over. So, the certificate of incorporation and the bylaws shall govern the relations among shareholders, the directors, the officers, and the corporation. To the extent the certificate of incorporation and the bylaws don't provide for a matter, this act governs. You recognize that, as I just pulled it out of the Uniform Partnership Act and took out all the exceptions, because you really don't need any exceptions. If you're really a believer in private ordering, this is where we're going to separate the real private ordering people from the phonies. Now you say, well, it's an enabling statute, so I need a second provision in my corporation law. To the extent that the corporation law of any state grants any right, privilege, or ability to its corporations, corporations of this state shall have the same rights, privileges, and abilities. Have I covered it? Is there anything you want in a corporation law that isn't here? And then I propose my own theorem is to be competitive. A corporation package can't differ meaningfully from this. That all of what you see in the Delaware corporation law is from the viewpoint of managers fluff. It's not anything that they're particularly worried about, because if they were worried about it, they could go somewhere else and get whatever that is. So you get rid of the judicial strategy. Corporate law is capable of melting down just like this to a system in which a state consists of a website, basically. It'll be who's got the easiest website to form the corporation on, because the corporation laws of the 50 states are all the same as this. The point is that this competition goes only one place. Competition deregulates. Now, this competition and this deregulation is beyond democratic control. Others have mentioned this before me, but I'm going a little more deeply into how exactly that occurs. So imagine that you are a citizen and you think there is a regulation that should be made on corporations. Where would you put yourself in this system? There are Delaware voters, there are other state voters, just think of that as California voters, and there are federal voters. The Delaware voters can't do anything about enacting their meaningful corporate regulation. For one thing, the legislature isn't making the law in Delaware, the council is making the law in Delaware. So the Delaware voter votes for a legislator, that's a button and lever that isn't connected to anything. Oh, but you could connect it. If you vote for your legislature's two-step process and they could do something about the council, and then you can get your regulation put in. Have you regulated corporations? No, because the corporations will simply leave Delaware and go somewhere else. So there isn't a way that Delaware voters can actually regulate, nor can California voters actually regulate. If they want to regulate, the first thing they've got to do is get rid of the internal affairs doctrine, because passing a California law under internal affairs doctrine will apply only to California corporations, which hardly exist at the public company level. If you want to affect them at that level, you got to get rid of the internal affairs doctrine. The first state to get rid of the internal affairs doctrine runs into a terrible coordination problem and a terrible public relations problem with the corporations, of which California has many. So the California voters can't regulate. The federal voters, there's been a lot of discussion at this conference about whether the federal government can regulate. Jim Park, I put him over here as the promoter of the culture of this isn't the federal government's business. This is something properly reserved to the states, and I respect Bob Thompson's opinion to the contrary, and that some things are moving to the contrary. But those things that are moving are small things. They look like big things to the people in this room. But in the big picture, they're tiny things. The federal government is still basically regulating disclosure. And sure, there are things happening as a result of that disclosure, but that's the private ordering. That's not the regulation doing that. Secondly, the United States Senate. Delaware has 30, 40 times as much representation in the United States Senate as it would have in a democracy. And these two senators have the incentives to trade anything they have for the protection of a quarter of their state's budget. So you can't get something through the United States Senate that would meaningfully regulate. And lastly, even if you could do that, you'd still be up against the internal affairs doctrine, that the corporations can move offshore and come back in their guise as foreign corporations regulated by the Cayman Islands. So last point here, is competition is really a multi-directional competition. On this slide, I've shown just the top states, but in this column, these are the shop-in. These are corporations that are headquartered in some other U.S. state and have incorporated in these states. Notice that they're shop out from every place, and the net numbers are over there in that right-hand column. But the point is that the shop-in column has a lot of corporations in it. And if you look at this in terms of trend over time, I use Subramanian's figures. These are CompuStat numbers. So just take all the corporations listed as public companies on CompuStat. Subramanian did this in 2000. I did this based on the 2015 CompuStat numbers. And what it shows is home state incorporation is pretty rapidly declining from 35% to 26% of the corporations. Delaware is increasing moderately, and the other states are also increasing moderately. We're coming into a world where corporations are taking their state of incorporation off of a menu. There's no big deal about where they happen to be located. So it's not just Delaware against the home state, it's everybody against everybody. Thank you.
Okay, that was was very interesting. All the presentations were very interesting. We'll open it up to questions. I'll get started with just an observation for Sean about this administrative alternative, which is kind of very different. In California, we actually have a process for approving merger transactions. It's called the fairness hearing process. There's about 6 or 7 other states that have it. It's a function, as I mentioned earlier, of the blue sky law. But a number of, Facebook has used it to do a number of acquisitions. A number of companies use it because it's very much cheaper than going through the SEC registration process. It's a process in which shareholders of the target company are given notice, and that you have a presumed expert in the Department of Business Oversight that holds a hearing and approves the fairness transaction under traditional blue sky principles, which in California have historically been very strict. Those are not disclosure-based principles, but they're substantive principles. Historically, we had an aversion to things like cumulative voting, non-voting stock, all kinds of shareholder protection kinds of things. So I don't know whether you want to respond to whether that's a possible model or an avenue for implementing your administrative process.
No, that's very interesting. I'd like to get more details from you about it. I think I think the big thing that the British and Irish system does is to sever the disclosure claim from the claim that something has actually gone wrong in this process. And it handles the disclosure part first, and insofar as the panel catches what's actually gone wrong in the process, that gets handled ex ante too. But it leaves the litigation ex post, but in a much diminished state. And I think I don't seriously think that the British system is the solution to the problems that Lynn I agree with and I've identified with Delaware. But I do think that something to sever to make it so that you can't just settle the Revlon for disclosure things, to sever the disclosure part from the substance part is, I think, the core.
So, yes.
A question, I think it's both to Sean and to Lynn. And I go back to New Jersey's great innovation in the 19th century, which was put through by a New York entrepreneur who wanted to create CCH. And he's the one who persuaded the state to adopt this revolutionary corporate law at that time. Why have we not seen such an entrepreneur for either your proposal or your proposal, both of which could profit somebody mightily, I would think?
Well, the answer from my point of view is I don't have a proposal. That all I'm doing is observing what's happening, what these forces are. And Delaware is either going to maintain its judicial strategy, or if it slips, you're going to have a meltdown. So I'm not advocating any particular thing.
And so my answer to that would be that time and consistent preferences of the defendants. So in order to get the model that solves the problem as a private ordering solution, like you're suggesting, or as an entrepreneurial thing, somebody has to want it and know that they want it. And I think who wants to get rid of these nonsense cases? My answer is everybody, except the plaintiff's lawyers. But that's in the ex ante. And the ex post, once the suit comes up, as many people have been saying, defendants love the suit and the settlement. And so the trouble is that we live sort of in the ex post world. The ex ante interest is this diffuse interest of all market participants, allegedly represented by people like ISS. But there's no real interest, I think, to lobby for it because it's a diffuse, not represented interest.
I guess I would say that there's, in addition to the plaintiff's lawyers who are for it, the defense lawyers are for it. The old joke about, a lawyer, if you're the only lawyer in town, you starve, but if there are 2 lawyers, everybody makes money. So I think, from my observation, that the defense bar may grumble about these things, but they also make money too, just like the plaintiff's bar maybe not as much at the moment. Yes, Joel?
Sean, I had a question about, in the Irish-English model, the ex post litigation, does that occur after the transaction has in fact closed? Or does it occur prior to the closure, and can the shareholders then try to stop the close?
So I'd have to punt that to Dan and Glenn. I don't know. I think that it could happen either way, but that's, I shouldn't answer that question.
Yes, Tony?
So I had a question for Professor Lopaki, and it touches on some of the things that were said yesterday about indeterminacy, because I notice in a lot of the literature there's a lot of discussion about the supposed indeterminacy of Delaware law. But then I remembered what Professor Kim said yesterday when she was working and she'd be in another jurisdiction and there wouldn't be an answer. And I've litigated in a lot of different jurisdictions. And I do have to say, just from a practitioner's standpoint, those paragraphs do not bother me. I mean, it's nice maybe if somebody's going out and pulling out extra words, but that is not going to take any hours out of my day.
Get paid for it.
Well, actually, not so much these days. But yeah, it's not gonna make my life any easier. And I've always seen indeterminacy as a product of corporate law that evolves from very smart people with an awful lot of money taking a look at the rules and figuring out where the interstices are so that you can have the next round of cases because people are maneuvering around them. And I guess my question to you is, where is this jurisdiction where I can actually file a case and I don't have this indeterminate corporate law? Because if I'm litigating and I'm in one of these NBCA jurisdictions, often the question becomes, okay, I've got a statute and I'm in the interstices of the law and I look at the actual case law in that state and eventually I run out and eventually the answer is, much of the time, look to Delaware. So where is this non-indeterminate jurisdiction?
I'm thinking that it's pretty much equal. You go in most states and there's no authority at all. You go in Delaware and there's authority, but it doesn't really say anything. Or it's set up to be, as was discussed yesterday, set up to be modifiable in the next round. So the surprising thing to me is that Delaware didn't. Well, it was surprising until I figured out how the competition worked. It was surprising to me that Delaware didn't have any rules. That if corporations really want predictability, there would have been rules.
Stephen?
I agree with Lynn to a certain extent about the indeterminacy issue, but I also agree with Tony to a certain extent. Yes, the corporate opportunity doctrine in Delaware is a mess, but on the other hand, Bras gives us a safe harbor where if you present the opportunity to the board and the board turns it down, you're home free. If the question is, can you have a poison pill in Delaware, the answer is yes. Can you have a dead hand pill? The answer is no. I mean, let's not overstate the extent to which Delaware law is indeterminate in comparison to California, where I would bow to your expertise in this area, but I think it's still not 100% clear if you can have a poison pill under California law, right?
It isn't. In fact, I was expert witness in a case where that was an issue, and Professor Subramanian from Harvard was the opposing expert, and we were debating that. Unfortunately for us, or for that question, the case got decided on an entirely different issue. So we don't have to do that.
So, I mean, indeterminacy, yes, but let's not pretend that there are no answers, right?
Steve, imagine you present it to the board, and then later a dispute arises. Somebody says, well, it wasn't presented really fully to the board. Delaware, I think, is going to look at that situation and decide who are the good guys, who are the bad guys, in the Ed Rock style.
Yeah.
They're going to decide for the board.
Yeah.
That's not very indeterminate, actually.
It might be the board trying to challenge what they themselves did, some member of the board.
I hate to change the subject. I have a question for my esteemed colleague, Jill Fish, because I really liked your paper, and while you were giving the paper, I really thought it made me think, why do charter, and I don't know the answer to this, I'm going to ask you, it's a true question, actually, which is why do we have, for charters, the shareholders and the board have to buy in, And for bylaws, we have this sort of, depending upon the state, who can vote, et cetera. Is there some theoretical construct for why the difference, at least in Delaware, and how we can look at it? And is there sort of a second paper here?
There's definitely a second paper, and that's why I bracketed the question. Because I've only started, particularly after the, whatever it is, Freichter or whatever case that I put the site up for. I'm not sure conceptually how we should think about the difference between charter-based private ordering and bylaw-based private ordering. Because on the one hand, you might say, well, I love the idea that the board and the shareholders independently can change this, and that's what Leo says in Boilermakers, and it all seems really good. On the other hand, given some of the practical constraints, you might say, well, no, I really want both of them to buy in, and we talked about this a little bit yesterday when we were talking about selecting the state of incorporation, right? So you've got this language in section 102 that seems to be broader with respect to charter power than the language in 109 about bylaw power, and I'm not really sure if that is intended to reflect the, some sort of difference and some sort of respect for the sort of dual decision making or not. But I don't know the answer to that either, and I'd love to think about it more.
But it's not dual, really, because only the directors can initiate the charter amendments, right? So the shareholders really don't have an equal say.
Sure, it's not an equal say, and there's also the problem of IPO charter provisions, which, we all know the terms aren't priced, the shareholders don't really buy in, the shareholders buy into the company, even though they hate the provisions in the charter, so, yeah, all of those are obviously limits.
So I also want to comment on this paper. I think that what this paper also shows is that there's a lot of activity now of action is happening out of Delaware, and is consequential. And the bylaw shareholder activism and bylaw proposals is one area. And I think that's going on there is that managers can contest shareholder proposals and ask them to see permission to exclude them. And apparently there are these studies that talk about it that find that managers contest 40% of the proposals. And SEC runs no action and 75% of those. So 30% of the proposals are even now coming up to a shareholder vote. So I think that supports your point, and it also suggests that the SEC discretion in the no action letter is becoming also an important venue. This outside Delaware is affecting government.
Yes, Simon?
Yeah, Jill, when you do that second paper, you might want to look at Virginia. They actually reverse the hierarchy. Bylaws control over
Really?
the charter.
I
Yeah,
did not know that.
very unusual. And I was going to say something about Virginia for Gil's paper, because I agree with Lynn that Virginia has exculpation of officers. It's by default. And I think Nevada is not just competing with Delaware. Nevada's competing with a lot of other states that would like to compete with Delaware. So I think the market is split. Lynn, I did wonder about why you would be more comfortable with arbitrators. I mean, talk about uncontrollable, indeterminate discretion. Maybe I misunderstood.
We had part of this discussion yesterday.
Yeah.
No, I'm not in favor of arbitration. As I told you yesterday, I'm terrified of arbitration. What I'm doing here is not advocating something. I'm just trying to describe what this system is, how it works, and where it's going.
The final comment for Sean. I mean, didn't Edgar versus Might say that you can't have state regulators of interstate commerce like that? So I'm not sure how the takeover market, I don't know how your law works, but that's what the Supreme Court shut down in 1982. You can't have an Illinois state regulator sit there and decide what happens in interstate commerce. So.
Well, as a California lawyer, there are a number of, California has really since the early part of the last century, been concerned about what they call tramp corporations, corporations that are incorporated here, are headquartered here but incorporated in other places. And they always felt like they didn't want them to have, it was even in the California Constitution at one point, an unfair advantage, these tramp corporations. So over the years, there are any number of corporate laws. The most famous is California Corporation Code Section 2115, which basically says that if more than half of your stockholders are in California and more than half of your business is in California, then there's a whole list of statutes of the California General Corporation Law that apply to you. That is less relevant today because New York Stock Exchange and NASDAQ listed companies are accepted, but it does come up. Most famously, it came up in the Delaware Supreme Court decision of examining. And the Delaware Supreme Court did not think much of the California statute. That's Delaware. But I keep pointing out, here in California, a California Court of Appeal has specifically upheld the constitutionality of 2115. And no court in California has said it's unconstitutional. And we do have a reported California decision. Well, that's point number one. Point number two is, it's a long list of statutes, some of which may, Delaware basically said this offends the internal affairs doctrine. Some of those, probably most of them, would legitimately be within what everybody would agree is the internal affairs doctrine. Some arguably are not part of the internal affairs doctrine. So maybe, not all of 2115 is invalid. Leaving 2115 aside, we have a number of other specific statutes that have different tests, including director inspection statute, the shareholder inspection statute, the ability of the court, the Superior Court of California to appoint directors and to decide director contests in California. All of these may run afoul of form selection bylaws. Finally, I heard yesterday that there is some judicial authority for validity of form selection bylaws in California. I would point out those are federal district court cases, and everybody mentions one Superior Court case, which is not a reported decision in California. No appellate court in California has ruled on the validity of form selection bylaws. So a lot of, I think, questions there with California. And California, it's a big state, and it chooses to kind of go in its own weird way, So I don't think they're going to stop. Yes.
So two questions. Lynn, as you talked about your enabling statute, it occurred to me that it was sort of the short form version of the Delaware Limited Liability Company Act. And I wonder if that's, in other words, I wonder if it's already out there, and we basically now in Delaware, you can choose to be a corporation or a limited liability company. If you want to be wholly private ordering, just go with the LLC, and you've got it. It causes a lot of problems for judges, of course, because turns out lawyers aren't that good at private ordering. And then Jill, is Unical a success? Was that the sort of premise on which your paper was built? I mean, did you, if you're going to sort of invoke it as a bylaw constraint, do you think it was a successful intervention by the Delaware courts, or not?
Well, I actually think it was, but I also think that it's even better applied in the sort of bylaw context than the takeover context. I've always kind of struggled with the Unical analysis in the takeover context, of why takeovers should be kind of separate from other issues. And I think in particular, because I really like the aspect of Blasius that says, the whole legitimacy of director primacy in this corporate enterprise is because of the shareholders' really broad election rights. And I think that's a justification for Unical in that context that's really distinctive from, takeover cases.
Yes.
So two comments. One, Jill, when you go to your next paper, I think one of the things you have to talk about is what is the proper purview of a bylaw? Because many of these cases, including some you mentioned, really go to the question of is this in impingement upon management's power under 141A in Delaware's case? Or is it the proper subject for a bylaw? So we would all agree that if the stockholders were to pass a bylaw that said, please build a factory at the corner of 26 in Santa Monica, that would be an inappropriate bylaw. And I think that's something that when you talk about the role of bylaws, almost as a filter before you get into it, you need to grapple with that subject, because that's really where all the 14A9 opinions, for example, come down. Most of them are that question, obviously not as stark as the one I just used as an example. And then I want to ask, I want to raise another issue on the arbitration side. I agree with you. I think the risk that arbitration that you would put in your charter, or perhaps even in your bylaws, I believe the FedEx Chevron case basically equates the two as almost equal dignity. A provision that said in all intra-corporate affairs, we will submit those to arbitration, thereby cutting off, theoretically, the entire right to sue of a plaintiff shareholder in a public court. I've worried about that. I think because that would do a couple of things. Not only would it sort of choke off the court system, but it would stop, if it became endemic, it would stop the flow of written opinions and a court-made regulatory system, very frankly. It is a regulatory system. I disagree with you on that. And all these things that we've all come to learn about, special committees and lots of other things, or how you do things, those are all, if a legislature had adopted them, they would have been a regulation, and the courts have adopted them, there's another form of regulation. But what do people think about that? I mean, I've sort of thought that at some level, because the plaintiff would get shut out completely, and 115 inched up on this, and the Chevron FedEx cases inched up on this, could the next step be that we carry the contract analogy of Dartmouth College and the like to the point where you say, well, yes, these are enforceable contracts between the shareholder and management.
Justice Stein really put his foot in it in the Boilermakers case by making that analogy so strongly to contract, that these documents are contracts among the parties. Now Delaware is going to have to back off of that idea, and I think they already are in the Arbitration Act backing off of that idea, that there are real contracts, which are things people sign, and then there are these other contracts.
Yes, and I think if you want to talk about risks in terms of, it wouldn't happen overnight, but if you want to talk about a risk to Delaware's dominance, that would be a creeping death. And my guess is it would be against public policy to restrict the plaintiffs that much. I know that's something we thought about when we briefed Chevron and FedEx.
The trouble is that it's the Feds doing this. It's the Supreme Court of the United States doing it, and they're doing it viciously to consumers. That we go online and click on something, and all of a sudden we've agreed to arbitration that we don't even know about. How are they going to make a special rule for the corporation?
Well, but you've actually entered. Even when you're clicking, you've actually entered into a contract when you say, "I'm buying this thing." I mean, it's you and selling the buyer.
Contract when you click to buy your shares in stock.
Well, but what's underlying that contract is the state shareholder manager structure, and that's where you have to look for the contractual, the contract. And the real question is, does that contract go that far?
I was just going to say CTS versus Dynamics. I mean, it did uphold internal affairs over the Williams Act, so it's not as if it's just going to be a laydown that the Federal Arbitration Act is going to roll over every state law. So it is going to turn on whether you can contract around these things or not. And I think even putting things in the charter can't conflict with statute. It can't conflict with the Constitution. So it's not as if there's this ultimate contract tyranny. The other thing I'll point out is 2 years ago, Vice Chancellor Laster in an LLC case just celebrated concession theory. So there's a lot of back resistance to free contractarianism in Delaware law, that you can't contract over everything. The state ultimately does control what's going in that contract.
In the LLC situation, I view as a different one. I mean, that is such a contractual entity, a real contractual entity.
But he resisted it even there.
Yeah, well, that's good.
Tony?
So first, I'd like to say to Professor Lopaki, since I'm asking him two questions, first of all, I really enjoyed your paper. I don't know much about the Federal Arbitration Act, and I was wondering if one way of threading the needle, when you look at the FAA, it says it involves or extends to contracts involving a transaction in commerce. So would one way of threading the needle and allowing Delaware to get around the FAA be to say, well, for corporate governance, for instance, M&A litigation, much as you have the divide in securities law between buying and selling and corporate governance acts, M&A litigation doesn't involve a transaction in commerce. You already own the shares at the time whatever the merger is taking place is. You're not selling them, because if you sell them, you probably lose standing. So is there actually a contract here that involves a transaction in commerce? And might that be a way of threading the needle and getting through it?
The contract is the arbitration bylaw. So that's not related specifically to the merger in any way. It's not the merger transaction that's going to trigger the arbitration. It's triggered by the bylaw.
Okay.
I think we're supposed to break now. Is that right, Joel?
Yes.
Yeah. Okay, so this is very fascinating to me.
Okay, if we could get started again. Song, would you put your head out the door and get folks noshing back in? Our next panel is going to be moderated by somebody who became a friend of mine over the internet long before we actually met. Francis Blagey of Eckert Siemens is well known to everyone who follows Delaware corporate law for running the Delaware Corporate and Commercial Litigation blog, which is probably the essential source on Delaware corporate law. You'll notice in recent years that the Klein-Ramsar-Bainbridge casebook new cases typically include some of those that Francis has identified for us as the 10 most important Delaware cases of the preceding year. He practices, obviously, in the corporate and commercial area, does a lot of work with LLCs as well. He's a certified mediator and basically has become his own brand name in terms of his blogging exploits. And so it's really a great pleasure to have him out here again, to see him again, and to have him moderate what should, I think, be a very interesting panel. So, Francis, thank you. Thank you. Thank you.
Thank you for that kind introduction. Appreciate it. It's a thrill to be here. I'm a big fan of Professor Bainbridge, and I'm happy to introduce this distinguished panel. I've cited from the writings of every member of this panel and many of you in the audience. Our first speaker, Christine Hurt, is the Associate Dean and the Rawlinson Professor of Law at Brigham Young University's J. Reuben Clark Law School. Together with Gordon Smith, they have recently published a new edition of the well-known treatise, Bromberg and Ripstein on partnership law. Also with Gordon, she's the co-founder and contributor of the popular blog, The Conglomerate, which I'm sure all of you here have read. Professor Hurt's teaching and research focus on securities regulation, business associations, corporate tax, microfinance, and sports. Our paper today will focus on Delaware's prominence in the alternative entity area, LLCs, LPs, and what our dearly departed friend Larry Ripstein used to refer to as uncorporations. I don't think many people use that word anymore, but I want to give a shout out to him for trying to get that word to stick. Professor Hurd examines also whether the use of master limited partnerships will extend beyond the publicly traded, beyond the finance and energy industries.
Great, thank you. I want to thank Steve Bainbridge for inviting me and Rachel for dealing with my not answering emails on a timely fashion. But I'm really happy to be here. When I saw the topic of the conference, I was attracted to it. I remembered in 2008, Larry Ripstein and I put on a mini conference about this, and we had great papers from Bill Carney and Chancellor Chandler and Bob Thompson, and it just made me very nostalgic, and as in most days, I wish that Larry were here. But I couldn't figure out what the corporate law hook that I wanted to talk about would be. As Francis said, I've been spending a lot of time in the partnership world in the past few years, and in working on the treatise, I took notice that there were a lot of MLP cases in Delaware. If you talk about you need a flood of cases to create law, there has been a flood of MLP cases in recent years. And so I thought I would focus my chapter on this phenomenon of the publicly traded partnership. As Francis said, I teach corporate tax, but I've also taught partnership tax a couple of times, and I actually start both classes talking about this mongrel of the publicly traded partnership. Now, I can't be too harsh on them. Once, a very long time ago, I was among a cast of thousands who created the AmeriGas MLP, so I guess I'm part of the problem as well. Okay, so in corporate law, at law firms, in the courts, we talk about these partnerships as master limited partnerships. The tax code refers to them as publicly traded partnerships. They mean exactly the same thing. They could be, depending on your stance, you could consider master limited partnerships either Frankenstein monsters or maybe golden labradoodles. They either have the worst of all worlds or the best of all worlds. They are legally organized as limited partnerships, but they are publicly traded on an exchange. Their units are registered with the SEC. Typically the sponsor, so Shell might be the sponsor, and Shell might create this master limited partnership, and then Shell would own one class of units, and then these other units would be sold to the public. They're usually called common units, but there's nothing common about them. They do not look like common shares at all. Because they're organized under a limited partnership statute, particularly the Delaware statute, there's no right to have an annual meeting. You do have the right to vote for the general partner, but the general partner is an entity. You don't have a right to vote for the directors, the humans that run the general partnership. So they don't have a lot of the indicia of what we would think of as common stock. They're much more like preferred stock or maybe even a bond. They usually have a right to a minimum distribution and to incentivize the general partner to increase distributions. The general partner or the sponsor will have these incentive distribution rights. So as the distributions get higher, the general partner gets more of a higher percentage. So this is if we talk about private ordering of master limited partnerships, this is what is used to align the interests of the general partner with the common unit holders. Now the trick is, and what makes them attractive to investors, is that they get flow through taxation. So they are not taxed twice as every other entity on the exchange is. They're only taxed once. And so if you remember in 2007, I guess, the brouhaha around the Blackstone IPO, as Vic Fleischer told us many, many times, Blackstone being able to use the master limited partnership or publicly traded partnership structure enabled them to save, I think it was $150 million a year. Right? So it's a lot of money to avoid the double taxation. So it's a strange combination. If you think about it, I'm not sure why that doesn't show up. But you have the ultimate separation of ownership and control. If you think about the theory of the firm. You have publicly traded shares held by people that don't know each other, and until recently this was very heavily a retail investor product. And you have, under Delaware law, the elimination of fiduciary duties, and then you don't have the corporate statute as kind of a background or backup, as we've been talking about, either for fiduciary duties or this sort of manager-shareholder balance. Okay. So the trick is, and why doesn't every corporation on the New York Stock Exchange or the NASDAQ become a publicly traded partnership? Because you have to have qualifying income. This began as just being passive income. So this is why you have KKR and Blackstone. I'm blinking, because most of their income is passive income. But a third of all MLPs publicly traded right now are energy companies, because there's this big front door, it's a front door, for basically operating companies, but they operate in the oil and gas or natural resources or minerals area. So interestingly, if you're thinking, wow, does my company fit into E? There were new Treasury regs that were published in the Federal Register on January 24th. There was a moratorium, as you might remember, on the 21st that said no regulations can be sent to the printer until they were vetted by the White House. Because the effective date was on the 19th of January, Treasury sent it to the printer anyway. So they have two stories. One story is that the White House okayed them, and their other story is the White House didn't need to okay it because they were effective on January 19th. So it's unclear if they will be clawed back. But it vastly broadens and gives a lot of examples for E. So if you're in transportation or storage of any of these things, it's just been broadened. The solar people wanted in, and they cut them off. So this is sort of the old world oil and gas and not the new world. But traditionally these were meant to be depleting assets or wasting assets, and I guess solar hopefully is not a depleting asset. So we combine 7704 with the Delaware statute, and we get this publicly traded entity in which we can eliminate all of the duties except for the implied covenant of good faith and fair dealing. So if you look at the Delaware Department of Corporations, which is called the Delaware Department of Corporations, they don't talk a lot about alternative entities on the website, but they do in their annual report. They split it out. So unfortunately, they flipped the columns from this chart to this chart. So corporations here are orange and there are dark blue. And of course the big ones are the LLCs, which are light blue and red. And then the LPs are green. If you can see the tiny sliver, that's statutory trusts. But what's interesting is that obviously LLCs are ruling the day as far as new registrations. But if you look at the annual increases, and that didn't show up, and I apologize, it's really the LPs that are having the greatest annual increases among Delaware limited partnerships. This chart could probably go down in the history of the most deceptive charts. Because it looks like LPs are taking over the world, but it's really just because the scale is so, just goes from 0 to 20 and not 0 to 100% or something like that. But except for 2013, you can see that LPs as a percentage increase are kind of gaining ground in Delaware, which is interesting. Now the IRS just keeps, they can tell you how many LP tax returns are filed every single year, but it doesn't account for LPs that have died, so it's hard to get a sense. Here are the MLP IPOs. They're about 10% of the IPOs every year. You can see 2009, just like the 2009 regular IPO market, was a bad market for MLP IPOs, and they were zero. So why has it climbed? I think it's climbed because of check the box. It climbs for 7704, right? These are not entities that would have passed the Kinder regulations, if you remember that. It would have made the Kinder regulations explode if you tried to run it through this, because it would have failed on all four fronts. 2014 was a really big year for MLP IPOs. So it's an asset class. There are funds that I was just looking at Enbridge. Enbridge has 13 analysts that follow its MLPs. So it's big. It wasn't big in 2016. It follows basically oil and gas prices, I think, because a third of them are oil and gas. This is the IPO market as a whole. Okay. So what about this good faith and fair dealing? Does it protect the common unit holder? So we've had a slew of cases that went to the Delaware Supreme Court. All of these except Gerber, the unit holders lost, right? And we're all familiar with these cases, and people have written about them, and much of these early cases are trying to whittle away at, okay, so you got rid of common law fiduciary duties and you tried to write your own and you completely messed it up. But now the companies aren't messing it up because now they know how to say it, and how they say it seems to work, right? And the courts say, yep, you have eliminated everything except the good faith and fair dealing, and this does not rise to the level of good faith and fair dealing. The Gerber case was sent down on remand and then it was settled, but all the cases after Gerber seem to distinguish Gerber, so it's probably not going to be the one below. The case that made me pause was one in late 2016 where the limited partnership agreement said that we're not going to change the tax allocations on you, but it said we could do a merger if we run it through the system, you know, the special committee. They ran it through the special committee and as part of the merger changed the tax allocation. The Delaware Chancery Court said that that was okay. I don't know, I've looked, I can't find whether it's being appealed. People in the room may know a lot more about this than I do, but that struck me as it's pretty harsh when you think about when you buy, if you bought a share of stock, you know that you can lose your principal, your investment, but I don't think you realize that next year they could not distribute money to you, but send you a tax bill that you had to pay that maybe you weren't expecting. Now, it changes your, you know, it makes your basis go up, it makes your capital account go up, and so you could sell your shares and take a loss, but it'd be capital loss, so you just had ordinary income. So I'm not sure I would be really happy about that. Now, Francis, on his blog, and he told me on the telephone, oh, there's been a case where the unit holders won. And I was so excited. And I went to go look it up. It was decided in January. Basically, fraud involved, it violates the implied covenant of good faith and fair dealing. So if we wondered where good faith and fair dealing was, we know it's not as high as the duty of loyalty. It might be as low as fraud, right? We don't have a lot of cases saying, okay, this isn't fraud, but it doesn't sound like good faith to us. But we know at least that fraud would violate the covenant of good faith and fair dealing. But if that's all the implied covenant is, then why do we even need the implied covenant? We have fraud laws, hopefully, even in Delaware, I assume. We have some fraud laws. So I would assume the implied covenant has to do something a little bit more, but we don't seem to have some cases fleshing out where kind of the ceiling of good faith and fair dealing is. Now, I remember from yesterday, Jill asked the million-dollar question or billion-dollar question, which is, can't private ordering sort this out, right? So people, if they buy this unit, right, if they buy these common units, surely they can figure it out. Surely they can read the prospectus that says you don't have any of these duties, you don't have any of these rights. And I think that's a really good question, and it's kind of an open question. It's a small enough class. I'm not sure how to design a study to see about value, but I'm reminded of now Chief Justice Ryan and his paper they really didn't think that private ordering could fix this problem, right? That the one great thing about the corporate statute is that it has this whole body of fiduciary duty law that you can count on and that fills in the gaps. And they were just talking about normal limited partnerships and normal LLCs where you do have sophisticated parties who are sitting across from each other. And in here we don't have that case. We have much more of a separation of ownership from control. So it'll be interesting to see how the MLP class continues, and I'm hoping to do more work on the paper and think about whether private ordering can fix this. But it's just such a strange instrument to me that it's not really common stock. If people are just buying it for the distribution, then it seems to be more of a bond or more of a preferred stock, and generally preferred stock is bought by slightly more sophisticated partners and not just the general public. I was thinking in this case, the Brinkerhoff, the case that this reminded me of was the benchmark case. It's in Gordon and Cindy's Disorder book. That was a chancery case from 2002, if you don't remember it. Benchmark had bargained for all of these protections in the Articles of Incorporation for their tranche of preferred stock. It said you can't do this, you can't do this, you can't do this, except. And one of the exceptions was mergers, and so Juniper just set up another corporation, merged itself into it, and changed the articles. And it was decided by Vice Chancellor Noble, and he said, these are really sophisticated parties. You know how to write things. We're going to honor your ability to contract and freedom of contract, and that's what we do here. And so Benchmark lost. Here, this is not preferred stock that was set down at a table by a very, very sophisticated investor with a company that they knew inside and out. So, I don't know, it strikes me as the same outcome, but not for the same reasons. If we believe that there should be fiduciary duties in corporations, it seems really strange to say that a publicly traded partnership is different. And it makes you think, yesterday Bob was talking about the interplay between the SEC, the feds, and Delaware, and it's a dance, and it works out. And here we have a third party in the dance, which is the IRS, right, or Treasury. And so Treasury says, oh yeah, you can be publicly traded as long as you have this special kind of income. But was the IRS really thinking, oh yeah, and you don't have to have any fiduciary duties, even though all your neighbors on the New York Stock Exchange are going to have fiduciary duties? And when Delaware says, well, we think LPs can eliminate all their fiduciary duties, it's a contractual entity, and people are bargaining, were they really thinking about master limited partnerships when they were talking in that way? And I know that Gordon's going to talk about the sort of corruption of corporate fiduciary duties. So maybe it seems illusory to say, oh, we should treat them like corporations where we love fiduciary duties and we nurture them and we protect the boundaries of them, because maybe we don't do that, but we do it a little bit more than in the publicly traded partnership space. So I look forward to your questions.
Very picturesque building there.
Nice.
You guys are getting a lot of PR.
If I had a building like that, I'd promote it. Well, thank you. I can't wait for the question and answer session. It's very interesting. Our next speaker, Gordon Smith, is the Dean and Professor of Law at Brigham Young University's Clark Law School. He is a leading figure in the law of entrepreneurship and fiduciary duty law. He is the only member of the panel who was a practicing Delaware lawyer. And as far as I know, do you still maintain your Delaware license?
Well, I'm inactive.
So So you don't have to worry about the CLE requirement.
No, but I still pay them every year to be enacted, yeah.
He is the co-author of a casebook on business organizations and is co-editing a book on, a research handbook on fiduciary law. His paper today explores the historical definitions of the duty of loyalty, such as the seminal Delaware decision in Calif versus Lowell. He is going to explain how the Delaware courts define the duty of loyalty by reference to customs and norms, and because of this, the definition is bound to change with time. And he argues that one of the most compelling threats to Delaware is Delaware's dominance is the corruption of loyalty in society. And there's also a part of his paper that will discuss the concept of corpus linguistics. If I have that right, and examines the change in the meaning over time. Thank you.
I'm going to assume we don't want to change the color scheme, so thanks for giving us that private ordering option. So thank you, Francis, and Steve, thanks for inviting me, and thanks for being patient with my difficult schedule now. I used to wonder why deans were like different people, but now I know. But I still love this world most, so grateful for the opportunity to come and talk about a topic that's become increasingly interesting and important to me. I'm going to start with a case that we all know. I think many of you will recognize that as the Hotel Bristol from just north of the New York Public Library, which became this building and was the subject of litigation in Minor versus Salmon. When we talk about Minor versus Salmon, we often focus on the strictness of the duty that was articulated there. We love Cardozo's language. He talks about the duty of finest loyalty, like it's a nice cheese or wine, I guess, if you're that sort of person. But and then, of course, this language, this sort of impenetrable statement that it's not about honesty alone, but the punctilio of an honor of the most sensitive. And so we walk our students through this. We talk about how the Minor and Salmon were joint adventurers, and talk about the strictness of the duty in that context. I think I want to focus a little bit on something else that's going on in this case, and that is this distinction between the worlds of contract and fiduciary. These have become merged in our minds because of Easterbrook, Fischel, and others, but traditionally these were really quite different spheres of economic activity. You were either in the contract sphere or in the fiduciary sphere, and you can see that in Cardozo's language here, right? He's talking about the workaday world for arm's length relationships, and he's contrasting it to the world in which people are bound by fiduciary ties. And then he does it again in the next sentence. A trustee is held to something stricter than the morals of the marketplace. He's talking about these two spheres of economic activity, contract law and fiduciary law. And of course, in the fiduciary realm, he has a very strict notion of the duties people owe to each other. And this language, even though we like this punctilio sentence, this language is the language that maybe was more influential, right? It's unbending and inveterate, uncompromising rigidity, undivided loyalty. I mean, this is how he thought about the fiduciary relationships of these parties to this joint venture. Okay, fast forward just a few years. I call this case Guth versus Loft. I wish, is it Guth? Is that, okay. I had a friend named Marty Guth, and so Marty's influenced me to call it Guth versus Loft. Well, Marty was from Idaho, and if we should trust his pronunciation.
At least he wasn't from Nevada.
Yeah. When you read Guth versus Loft, you see echoes of Minor versus Salmon, and it's not accidental, right? Minor versus Salmon was cited by the Delaware Supreme Court in Guth versus Loft. And so they talk about strict observance of the duty, but here's the language, same
say, okay, look at that, inveterate and uncompromising in its rigidity. Right after this paragraph, there's a string cite, and Minard versus Salmon is one of the cases in the string cite. Notice that the duties that the court's talking about here are duties of corporate officers and directors. This is not a partnership case, it's not a joint venture case. It's the seminal corporate law fiduciary case in Delaware. What's the purpose of fiduciary law? To remove all temptation, extinguishing all possibility that the fiduciary would profit from their self-interested behavior. Now, I want to suggest to you that maybe Delaware courts don't talk like this anymore about corporate directors and their fiduciary duties, and that the world has changed, and we've moved from a world in which we've moved corporate directors and officers from a fiduciary sphere into more of a contractual sphere. And so we talk about fiduciary law in more contractual terms. Fiduciary law has become more like a bargain than a duty. Now, I think this is, as Francis said, I think this is actually traceable to changes in the broader way in which we talk about loyalty. And so I want to introduce you to, if you haven't been subjected to dinner with me when I've been talking about corpus linguistics, I want to introduce you to the notion of corpus linguistics. So corpus linguistics is a method developed by linguists to understand word meaning by using, by looking at naturally occurring texts, right? So we get big databases of text and search those databases and try to extract from those searches some sense of the meaning of the words and how we use them. We could just ask people, what do you mean by loyalty, right? That would be one way to do it, but of course we know when you ask somebody to do something, they're going to actually, and they reflect on it, it's going to distort what they say, and they may not actually be able to report to you what they actually do. Linguists call this the observer's paradox. We also know about bounded rationality, that people are subject to limits on their ability to introspect and understand what they do. So what we're talking about when we're talking about corpus linguistics is an attempt to observe people in their natural environment speaking and see how they understand a word. So let's take the word loyal or loyalty, and what you see is this is from 1800 to 2000, and this is just a frequency graph, right? This just shows how often, and this words per million, and this is Google Books database, right? So, so over time, we seem to talk about loyal and loyalty in similar levels of frequency over a couple of hundred years, right? This is a concept that has endured. It's not an archaic concept that was only talked about in the 1800s. You see a spike there around the Civil War for the discussion of loyal, and we'll talk a little bit more about that. It's a little surprising we don't see a spike in the 1950s with the talk about loyalties and McCarthyism, but this is, so we talk about this concept over time, but I want to suggest to you that throughout that period of time we've changed the way we talk about loyalty. That it actually has come to mean something quite different today than it did in the 1800s. So let's take a look back in the 1800s. We can go back further than this, but for purposes of illustration, we'll start in 1870 to 1900s, the last 30 years. And this will, it sort of picks up, you can see some Civil War references. The list I have here are words that hang out with loyalty, right? So if you go into in this case, the corpus of historical American English, and you tell the corpus to bring back to you what words are most commonly associated with loyal or loyalty. This is the list you get. This is the 20 most common words that are associated with those concepts. Okay, and I've color-coded them. It's pretty rough, but basically you can see some references that look like they have some references to the Civil War and loyalty in the war between the states. So obviously the first one is states. League, if you go down in, you can actually see how the sentences, and there were lots of, people would form leagues. I think we form associations now. We don't do leagues, but except in sports. But so these are leagues of loyal citizens, it's sort of, again, a Civil War thing. We have governments, knight, I did not dig down into that one. And then north, obviously, a Civil War reference. So we have these sort of, what I would think of as organizational concepts of loyalty, that you're part of some larger group and you're loyal to that group. We also have the interpersonal ones that are pretty prominent here. Heart, devotion, mind, soul, spirit, right? These are about friendships or about affinity relationships of some sort, and we use loyalty in that context quite commonly. And then the third color code was the orange or yellow one, which is looks like loyalty is a duty, or sort of loyalty is an attribute of certain people. So a gentleman is loyal. They're loyal by nature, or they have a duty of loyalty. Duty of loyalty in this case isn't a legal duty. They're just talking about loyalty and duty in the same environment. The black ones were ones that didn't obviously fit into any of those categories. Okay, so we'll go forward just a little bit, the next 30 years after that, and what you see is, now that we're out of the Civil War era, we get this more of the red ones, so we get more of the sort of interpersonal relationship, friends, faithful, devoted, husband, friendship, loving, okay, so these sort of interpersonal notions of loyalty. The organizational ones are still there. A loyal subject, right, that's a thing we still say, right, somebody's a loyal subject. Or a loyal citizen, or a loyal servant, still pretty common in that day, a loyal American. So we see that sort of organizational, and we see a little bit of the this sort of duty or loyalty as a virtue in the to remain loyal to someone, intensely loyal or honest. Okay, go forward now to the end of the last century, and now something completely different has happened, right? And I bolded the ones that that should look different to you. And this happens somewhere in the middle of the 1900s, right? Now all of a sudden, we still have this sort of interpersonal loyalty, but it's changed. Look, friends isn't even on the list anymore. Husband's way off. But we do have some of the. So that interpersonal sense of loyalty has changed. We still have a lot of organizational employees. It's changed to employees rather than servants, followers, staff, member, that sort of thing. But look at the bold black ones. Loyal customer. What does that even mean? Like what is that? Like what relation would that have to somebody who's devoted? I mean, when I flew Delta here, and I'm part of there's a loyalty program at Delta, right? But I'm not like going to war for Delta, right? I mean, I am in the loyalty program because they give me stuff when I fly it, right? I mean, so to say that I'm a loyal Delta customer is really just to say we've made a bargain, and when I do stuff for you, you do stuff back for me. So I'm a loyal fan. I actually like sports. I know, Steve, you're a big sports fan, but I don't know what you do for the Redskins. But I think it's not really the same as what you do for Helen, right? I mean, it's sort of like it's sort of different feelings that you have there. All right. So what's happened here is that I think what happened is that the notion of loyalty has become commercialized. Now, this is a different database covering.
I have to ask. I'm sorry. I hate to do this. I have
Yeah.
what Davis?
Oh, I don't know what that is actually. I was going to click down on that and see what that was. I can't remember what that was. I'm sorry. Yeah, I could find that. Yeah, you can. Searches are replicable, so you can do it, and I can find it out. So you see this sort of organizational loyalty is still pretty prominent in this next database, which goes from 1990 to present. Okay, so it's covering the same time. It's just a different search database. Right. Now, friends does show up in this one, but you see a lot of organizational ones, and you see this loyal fans, loyal customers idea, loyal audience. So when you look at this if you just look at frequency over time, what you see is that the idea of a loyal customer I mean, doesn't really even exist until the 1900s, and doesn't take off until, and look how late it is to really take off. I mean, I was a kid when loyal customers were invented, and it seems like it seems to have been invented by marketers, right? Because loyalty is seen largely as a virtue. It's seen as something you want to be loyal. It generally has good things. It's not always that way. I mean, we sometimes describe people as excessively loyal, or worse. I mean, it'd be worse to be described as fanatically loyal. That's a bad thing. But most of our loyalty descriptors are good. Here's loyal fan. So again, same thing. It's all sort of second half of the last century where this notion of loyalty comes into being. All right, so back to corporate law and how we regulate loyalty. I think what's happened is that we've changed over time. Now, one way we could do this is to just say, if you have a transaction in which the director or officer is disloyal, we could just prohibit that transaction. We could just say, you cannot engage in transactions like this, because to breach a duty of loyalty or to engage in a transaction that would be considered disloyal, or where you have a self-dealing or conflict of interest, this is just bad. Now, almost nobody does this, right? There are some circumstances, mostly in European countries, where the situation is such that the decision's been made, this is just so bad. For example, compensation. You can't vote on your own compensation, right? So that one's one where people, and at least many European countries, have just said, there's just no good reason to let anybody do that. But they're relatively rare. The more common thing that we do with loyalty transactions is say, you need some disclosure, and then there'll be some approval process, right? So, and this actually, even despite the sort of very strong language in Minard versus Salmon, this is what Cardozo wanted, right? He wanted Salmon to take the deal to Minard and at least let him know about it. That was Salmon's big violation, is that he didn't tell Minard that the deal was on the table, and if he had told them and then they'd worked it out from there, either through an auction or some other way, that would have been okay. So, and almost everybody, I mean, every country, I've done some looking at other countries, and almost everybody says, this is all right. This is an okay way to deal with loyalty. If everybody sort of knows there's a conflict and we go forth with that knowledge, then we're okay. We could have a situation, Sean talks about this, Sean, where you could say, we're going to tolerate self-dealing transactions, but we're going to have some, outside judge or panel or some group approve the transaction, so have that monitoring in advance. So that'd be a way to do it. We don't do it in the U.S. But then this is what we do also. So if we don't get that sort of prior approval, we still have this backstop that we're going to tolerate a self-dealing transaction as long as it's substantively fair. Now, this doesn't happen all that often because most of the self-dealing transactions are heavily lawyered and people take it through the process to get it approved. But we do have this possibility of saying, even if you are disloyal, as long as you act fairly, that transaction will be okay. Now, as far as I have been able to determine, we are either unique or almost unique in allowing this, as we in the United States. I've presented on this idea in lots of different countries, and everyone's sort of shocked, like, wait, what? How is it possible that you could have someone engage in self-dealing and you could still say that's okay? Like, what planet do you live on? And I say, what's, Delaware, country, Canada, and Mexico, okay, so here's how it works out, and this is just, one of many examples, but MFW, modern Delaware law, controlling stockholder transaction. Basically, we can go through this process and get the transaction approved by those who are potentially aggrieved by the disloyalty or by the conflict of interest. They have to be informed, so we have to have full disclosure, and the people who are subject to the potential complaints would have to approve it. But if that doesn't work, or if for some reason the process, going through the process, they hadn't successfully completed it, then the court always has this possibility of conducting a substantive fairness review, right? I want to suggest to you that this is really different from the way that Cardozo and the Supreme Court in Booth versus Loft would have thought about things, right? That we've actually changed quite a bit, and that change is that is reflected in law is something that's also reflected in our broader society about notions of validity. That this isn't just some accidental. That judges, when they think about what it means to be loyal, are thinking a lot about what's customary, what seems normal in a particular industry when they're thinking about what is acceptable. And what has become customary and normal is frankly advantage taking. And it is advantage taking within some boundaries, but my sense is that we wouldn't see as many controlling stockholder transactions as we do if stockholders weren't really benefiting from these transactions, and that suggests to me that there's some advantage taking going on. This is just really pure promotion at this point. So if you wanna see more about corpus linguistics, we have a website, corpuslaw.byu.edu, and there's materials on there. So if that intrigued you at all, feel free. Thanks.
Thank you, Gordon. That's, I don't think most people know as much about corpus linguistics as I'm sure we will hear about in the near term. Our next speaker, Lyman Johnson, is holds the Robert Bentley Professorship at Washington and Lee University School of Law, and also simultaneously holds a professorship at the University of St. Thomas School of Law in Minneapolis. His scholarship on fiduciary duties has been cited in Delaware opinions and by other judges. In addition to business association courses, he has taught courses in corporate finance and securities regulation. He's the only member of the panel that I'm aware of who has the distinction of being able to say that Chief Justice Strine has written a paper as part of a symposium honoring Professor Johnson's scholarship. I think he's published a couple months ago. The paper today that he will present is a topic that may come as a surprise to many of you, even if you're an expert in corporate law, that despite the thousands of Delaware decisions on fiduciary duty, there are precious few that examine the contours of the fiduciary duty of officers and the related principles that apply. So Professor Johnson has come to the rescue to address that gap, and the good professor will explain how Delaware's long silence on the fiduciary duties of corporate officers can be described as dominance by inaction, and that there are good reasons why there's comparatively few decisions on that topic. And I'll just briefly, so I don't take more time than he does, but I just think this is noteworthy. Just a few months ago, there was a bankruptcy judge in Delaware wrote an opinion, and in a footnote acknowledged that none of the parties cited to a case, and these were experienced corporate litigators, none of the parties cited to a case, nor was the court aware of a case where a Delaware court applied the business judgment rule to corporate officers. So in any event, Professor Johnson will explain why there's a good reason for that.
Thank you, Francis, and thanks, Steve, for designing, conceiving this conference, and Joel, you and Rachel, your staff, great hosts. So, my paper is pretty short, but I'm nonetheless going to summarize my main points right at the outset, and then I'll go back and elaborate. I do have basically just 4 points. First, Delaware law, and I include statutory law, but mainly I'm talking about case law, has been remarkably and I think surprisingly silent for a long time on various quite basic legal issues associated with critical players in corporate governance, namely senior executive officers, the CEO, the CFO, the chief legal officer, and others. I've been looking at officers for about 12 years or so, And the reason I find it puzzling is, maybe this is a debated point, but I think corporate success and corporate failure are probably more attributable to senior officers than to directors. And certainly, most of the misconduct is at the officer level. And yet, when you look at Delaware's body of decisional law, there are thousands of decisions about directors and relatively few on officers, and they don't settle basic questions. Second, I think there's several reasons for Delaware's failure to supply clear legal rules, but I'm looking for some more if you've got them, including what I call relatively weak demand for such rules from the corporate bar, largely the plaintiff's bar, but maybe somewhat the defense and even the academics. I think the perception, although this ebbs and flows, of sufficient, if not great, near substitutes in federal securities law. And in a nod to Stephen Bainbridge here, I think Delaware's director primacy governance philosophy, which pretty much remits officer-related issues to the board, not courts, for resolution. And people use the umpire metaphor. They used it yesterday, and Chief Justice Roberts has used the umpire metaphor for what judges do. But to extend that metaphor, you can't call balls and strikes in games that aren't being played. And frequently, because directors resolve these issues, courts simply aren't seeing them. Third, I think over the important formative 20th century period in which Delaware rose to prominence, I think their silence helped them, and at least it did not hurt them. So my paper doesn't really highlight what Delaware did affirmatively well to achieve dominance. I focus more on what Delaware did a good job of not doing. It simply didn't address these issues. Now finally, I'm not sure Delaware will be able to continue its silence on officers. I do think if it breaks its silence, even if, and this might be the irony in my paper, even if by articulating somewhat stricter rules for officers and directors, I don't think there will be any great upsurge in officer-related litigation. And I think breaking the silence might actually bolster Delaware's position and usefully underscore its strong commitment to director primacy. Let me go back and fill in some of these points. There is, of course, a surprising dearth of Delaware decision law on officers. Thousands of cases on directors, very few on officers. This remains true even after 2009, when, notwithstanding the dictum in the Guth versus Loft case, we really didn't have any holdings on fiduciary duties until Gambler versus Stevens in 2009. But notwithstanding that, we're not seeing a lot of decisions. In the Chancery Court, William Chandler certainly did in the Disney case. Chief Justice Shrine did when he sat in Chancery, and Vice Chancellor Laster has done this repeatedly. He is dropping footnotes. They are dropping footnotes saying there's some open issues here on officers. Will you pick up the cue on this? So notwithstanding that, we're not getting much law. Now, we don't have answers to the basic following questions. First, does the business judgment rule apply to officers? Who would ever question that with respect to directors? It's an open question on officers. Second, is the standard of care for officers the gross negligence standard applicable to directors, or is it the usual ordinary care standard applied to other agents? This matters because in Delaware, officers cannot be exculpated from care claims. If the standard is ordinary negligence, those officers are exposed to personal liability. Another question we don't know is why, if officers are agents of the corporation, which is how I conceive of them, but not agents of shareholders, why should shareholders be able to bring direct actions? know there's law here, but what exactly is the conceptual basis for permitting shareholders to bring a direct action against an officer? We don't know why, whether, and to what extent officers may consider non-shareholder interests in carrying out their responsibilities. There's a lot of dictum in Supreme Court cases that directors can consider such constituencies as long as they're not in Revlon. But Revlon is basically an optional statement right now. It's not too hard to stay out of Revlon. So directors have fairly broad running when they're considering non-shareholder constituencies. We don't know whether or to what extent officers can. And there's other issues too that are open that I identify in my paper, and I don't take a position on them. I point out only that they are open. And I think there's several reasons for Delaware's silence. One reason that's sometimes cited is there was no officer-specific jurisdiction until 2004, but I don't think that really matters because, as other people have observed, many directors, at least up until probably the 80s, maybe the 90s, were also officers. So you would have officers and directors, maybe 2, 3, 4, 5, on the board, and it didn't really matter that you couldn't get jurisdiction over them in their officer capacity because you could get jurisdiction over them as directors. I think that may have led the plaintiffs' bar, and maybe the academics, not to carefully refine thinking about why officers might be different than directors. I think a great example of this is the Disney case. There were officers sued in that case. Chandler said in his opinion, I'm going to treat officers like directors because that's the way you're teeing this case up. And only on appeal in oral argument did plaintiff's counsel, I'm happy to say they cited my law review argument, try to bring in a different theory, but of course the Supreme Court said it's too late. You can't raise this on appeal. I think the chief reason is that boards deal with officers ex ante in employment agreements. Although they use different language, they use cause, not for cause, they tend to use employment law language. And I think boards largely deal with officers ex post in severance arrangements, where they pretty much just settle up. And therefore, Disney again being an example, well, that was really about Ovis, Michael Ovis. The case turned into a question of board judgment. Did the board behave properly in dealing with Michael Ovis before he was hired? And did the board deal with Michael Ovis properly when he was being discharged? So there's a sort of morphing of these officer issues into board issues where, of course, they're going to get the business judgment. If a shareholder does challenge a board action, of course, if it's derivative in nature, you have to make a demand. And if the demand is refused, once again, the board gets business judgment rule. If demand is excused, you may be able to start the lawsuit, but at some point a special litigation committee may be engaged, and it again may move to dismiss. So there are some difficult procedural hurdles. All right, let me move to how Delaware's silence may have aided in its dominance. Obviously, I cannot establish a causal link here because there's so many other factors going on as to Delaware's dominance. But nonetheless, I think Delaware has achieved a sort of Goldilocks effect here. It has not articulated a rule that's too strict. That is, it's not too hot. And therefore, people won't criticize Delaware for being too tough on officers. But it hasn't articulated a rule either that's too cold. It's not too lax, therefore spurring criticism that they're too easy on officers. I think this leaves everybody sort of with hope springing eternal. That, well, maybe the rules aren't bad, or rather maybe the rules aren't necessarily good, but we don't know that they're bad. And the presentation in an earlier panel indicated that Nevada has settled a lot of officer issues, at least statutorily. But then I would wonder why there hasn't been migration if people really care about that officer issue. All right, third point, probably that I think is the most important. I think Delaware's undeveloped officer law is really a byproduct of director primacy and reinforces director primacy. I think you could have quite robust agency law principles apply to officers. But these principles remain undeveloped in case law. And they remain in the background as theoretically applicable, precisely because we have a director-centric governance system, where directors take care of most of these claims and courts never see them. And I think this reinforces Delaware's commitment to director primacy. Finally, there are a lot of other federal actors that deal with officers. The SEC brings a lot of claims against officers. They bring very few claims against directors. So they're sort of the opposite of Delaware. There are other federal bodies, the Office of Comptroller of Currency, that deals with a lot of financial institutions. They sanction individual wrongdoers. Justice, the Yates Memo, targeting individuals. So I think the existence of other regimes that maybe not only offer private plaintiffs relief under federal securities laws, but signal that somebody in our legal system is sanctioning wrongdoers takes a little bit of the pressure off Delaware to do something. All right, finally, can Delaware remain silent, and does it really matter? I think the likely vehicle procedurally for generating new law would be an action against directors that assert that a majority of them are not independent, coupled with a strong care claim against an officer. And this would prohibit the board from seeking an early dismissal of the officer piece of this claim. Now, I think, ironically, Delaware courts could refrain from using a business judgment review standard for officers, and I think they could actually adopt an ordinary negligence standard for officers, precisely because of its commitment to director primacy. Now, why is this? Directors in public companies must be able to delegate management to obedient, loyal, and careful officers. After all, it's officers, not directors, who are on the job full time. And the delegation ability, I think, is critically dependent on directors knowing that the people to whom they delegate management are held to sort of borrow from Gordon's social norms, pretty much the same standards as everybody else in America is held to, ordinary care standards. Second, Delaware's corporate statute for directors in 141E states that directors can rely on various people, including officers, and it would seem strange to say that a chief legal officer for a public corporation is somehow held to a gross negligence standard, when the Delaware statute says directors can rely on these critical people, but somehow they're not going to be held to the same standard as any other lawyer. And you could apply the same thinking to a chief financial officer, a chief compliance officer, a CEO. So I think this, such an outcome would simultaneously bolster director primacy and send a strong positive signal as to Delaware's insistence on corporate accountability. I was glad to hear yesterday Gil make that point, because it's something I make in the paper. But I think Delaware's position of dominance actually does permit it to try to distance itself from Nevada by not lowering its standards. but by insisting and signaling that we're going to hold the most important actors in the corporation, senior officers, to a fairly high standard. Now, I'll close by saying I don't think that's going to deter officers. I don't think that's going to stop them from taking risks. And I think most boards will continue to resolve officer disputes without litigation. So there's going to continue to be relatively few officer lawsuits, even as Delaware could articulate a high standard in a way that historically perhaps it could not have.
Thank you. So I think procedurally I should start the bidding, as it were. So a question for Professor Hurt is, and you probably heard this before, but it's worth repeating. Why would a rational person make an investment in a company pursuant to an LLC agreement that may involve fiduciary duties?
Yeah, I mean, I think it's an open question, and hopefully I'd be able to do a little bit more research into it, because if they read the prospectus, it should say these things about corporate governance. I think that the retail investors in MLPs are different than retail investors in other kinds of publicly traded stocks, because there is this minimum distribution requirement. And so I think that may sort of allay their concerns, perhaps, because there's this minimum distribution requirement. And I think it's a really good question. I do know that institutional investors have entered the field in the past few years, but before that it was a lot of retail investors. So it could be that people are making very sophisticated trade-offs between risk and reward, just like in buying a junk bond or something, or another sort of risky product. But it is strange that it's sort of it's not under the Trust and Enter Act. It's not under any corporate act, right? This entity, this contract, as you will, between the unit holder and the issuer. So I think it just presents some novel issues.
But even in the non-publicly traded context, someone could invest $1 million in an LLC, and you
Sure.
says that all fiduciaries are waived, so they would easily lose their money.
Yeah.
The managers of the LLC would otherwise breach a duty, right?
Can I follow up on that? Just because I've always been curious about the industries in which we see MLPs, and we talk in the paper about energy and I guess finance or financial services. And I'm wondering if that doesn't partly answer Frank's question, because to the extent that an industry is dominated by MLPs and people want to invest because they think, well, gee, that's attractive, they might not have any choice. It's the same as investors in the high-tech companies investing in dual-class stock companies, right? You know, gee, I want to be part of that segment. There really isn't an alternative. Do you see that going on, or?
Yeah, so most of these MLPs, they don't stand alone. They are part of a family, right? There's Enterprise Products Company LP, but it's sponsored by a publicly held company, right? So there are a number of things that you could, I guess, invest in this sort of enterprise family or the ETP family or whatever. So these companies are sort of carved out of other companies, and so it would be interesting to see if the people who invest in the MLP are the same people that invest in the parent company. I hadn't really thought of that. It's a good thing.
I thought it was a good question, but I don't know when we get the queue on this. So.
Okay, who's next?
I have a question for Lyman. The concept of director primacy, I wonder if it doesn't really go in the other direction, in the sense that it might underscore the desirability of actually lowering the standard on officers. And what I mean by that is, if we think of directors as managing the day-to-day operations of the business, and the officers as serving at the pleasure of the board, why doesn't that check that ability of the board to terminate the employee the executive act as a close substitute to litigation, and therefore make it less necessary for the officers to be checked by shareholders.
Okay, what was the first part of the question?
Well, it's right, because I think if you think of the board as being able to hire and fire the officers at will, subject to any employment agreement, but the directors being subject to only the occasional and, you know, less direct voting of the shareholders, you know, we can think of the directors as playing a more robust role in monitoring the officers. So why would we want to have a higher standard for the officers?
Yeah, there is the ability to let them go, but that's probably after there's been some trouble. And I think, because I believe in the ex ante role of fiduciary duties, we tend to see it as just an ex post sanctioning device. But I like to think that decision makers actually understand that they have fiduciary duties. And this depends on lawyers adequately communicating this, which I have some empirical evidence they don't do a good job of with officers. But if they understand that they are going to be held to an ordinary negligence standard, particularly in the oversight area, where they have most of the responsibilities, the board is charged broadly, but it simply cannot engage in meaningful oversight. I think you're going to get better behavior. Now, obviously, if they fail in that, you can get rid of them much more quickly than you can get rid of directors if you're unhappy shareholders.
I'm not sure who was next, but I'll make sure we get to you, Gordon. I'll start from the back.
So I just had a couple of thoughts. Gordon, on your work, which is, I think, super fun and interesting, I would be interested in seeing whether the term fiduciary in the trust context, meaning trusts and estates, and I know you can't do it with the databases you're using, but whether it has changed and become more commercial. I don't have the sense that it has from a talk I did recently, but that's so far out of my zone. But it strikes me as interesting that if it hasn't budged there, and that's where some of the roots of the term and the fiduciary duties are, that actually might help your argument to some extent, because it makes the commercial context even more commercial, potentially.
I don't know if I can jump in here, but yeah, so there have been arguments to move it. Langbein wrote a very sort of famous article in which he said, we really shouldn't be so strict about this loyalty thing, and he got a lot of pushback. My sense is that it hasn't moved, it's moved a little bit, but not as far as in the corporate area, and mainly because people in the trust area have been trying to hold firm, right, saying, hey, this is really...
That it matters there.
It matters, yeah.
Unlike here, yeah. And then, Lyman, I just wanted to say, have you asked the plaintiffs' lawyers why they're not bringing these cases?
Well, no,
I just texted one to ask him, and I haven't heard back. But it strikes me that, Delaware said to them at one point, gosh, you should use 220, and they did, and then Delaware said, oops, no more 220s. So maybe they're just being rational actors. They're saying, well, bring a couple, and then maybe we'll get a little discovery, and then the court's just going to shut us down anyway, so we're not going there.
Yeah, well, Megan Shaner's done some empirical research on violence, but she saw that there were many fewer cases being brought, but she didn't look at theories of liability. And to me, it would be very important, not that you just sue officers, I assume they sue officers all the time, but that they refine the claims to be more precise. Now, I know that these claims are pursued with some frequency in federal bankruptcy court trust. There is a D&O insurance policy that may be the only asset there. And with the board gone, the trustee is more than eager to tee up a claim against, for example, John Borzine at MF Lowell on a duty of care claim where there's a $150 million D&O policy, no exculpation. So there's a lot of those decisions, or a lot of those cases, they settle, and you don't get an opinion. And even if you did, it wouldn't really be authoritative as to what Delaware courts think.
I guess I would sort of challenge the notion that Delaware has anything or much to say about officer fiduciary duties. Officers are kind of strange in that they have the officer relationship, but they're, in public companies, almost inevitably employees. So, being from California, I would say, you have a public company headquartered in California. Their relationship with their officer is going to be governed to a large extent by California Labor Code and by California law. Even the restatement of agency would support the application of California law. It may be influenced somewhat by if there's an employment contract with a choice of law provision, that you might have to have a choice of law analysis by virtue of that. But the California Labor Code comprehensively prescribes the obligations of an employee, including imposing a fiduciary duty on employees. It always surprises me that plaintiffs kind of overlook that the employee owes a fiduciary duty, but that does come up. And the other thing I would point out, even in California, we have a statute, 2116 of the California Corporations Code, which is often said to codify the internal affairs doctrine. It says that the rights and responsibilities of directors are governed by the law of the state of incorporation. It doesn't say anything about officers. So it expressly refers to the state of incorporation with respect to directors, and I think very noticeably leaves out officers. So I would just argue that, Delaware doesn't say anything because it's really a matter of local law.
Well, I think I would push back against that. I think it sounds like that's another California variation on several things. Because the employment laws I look at, the employment contracts don't really deal with fiduciary duties. And I think it'd be a very intriguing question if the board could soften fiduciary duties for officers or even exculpate officers. I have serious questions as to whether that complies with Delaware public policy, whether it's permissible. But when you look at employment contracts, they tend to be obviously drafted by employment attorneys who think in terms of cause, not cause, and so on. So their whole mode of discourse is employment law. But they are fiduciaries in Delaware. They have fiduciary duties. We know that from gambling. And they're not exculpated. And the Chancery Court has said they are agents. And I think they are inviting the follow-on from that. Therefore, you have agent fiduciary duties. Now, if you've got a Delaware corporation in California, then you may have some special statutes here, but that sounds like a California.
But if they are agents, and Delaware recognizes them as agents, the restatement of agency says that you look to the jurisdiction that has the closest relationship to the parties and the transaction. If the corporation is employing the officer in another jurisdiction, whether it's California, Oregon, Massachusetts, isn't that the jurisdiction with the closest relationship?
Okay, well, how does that line up with internal affairs?
Does the internal affairs doctrine, is a relationship between a corporation and its employee, is that the internal affairs or not?
Well, senior officers, I would say yes.
But why?
But why?
I mean, I actually think he's raising a really good point.
No, it is.
Frankly, I never thought of before, but why would the internal affairs doctrine cover the CFO in Smith versus Van Gorkum, who, at least on the facts, never tells the board what he did, which was run a calculation not based on the value of the company, but based on a leverage buyout of the company, how you could finance it. Why didn't he have a duty to tell the board, and why is that an internal affairs question at all? So he doesn't get sued there because there's no jurisdiction and no one sues officers at that point in time, right? But why is that an internal affairs question? I don't think that's a foregone conclusion.
Yeah, I mean, it's a good question, but even to frame it again, it sounds to me like quintessentially internal affairs, that directors rely on officers, they appoint them, they delegate to them.
I'm sure Delaware would make this argument if ever presented with the case, but I think California might say, well, just hold on a minute there, suckers. That's our deal. I would if I were California.
Okay, are you saying that because of California statutes as described, or would you make that same argument in Maryland, and Mississippi, and Illinois?
They're agents. I mean, they're employees.
I mean, case of question, it's a request for a prediction. If there were a case teed up in Delaware where the court had to decide one way or the other if the business judgment would apply to officers, do you have a prediction about how that would be decided?
Well, I think in Gamble versus Stevens, I don't think the court actually used the business judgment rule framework for the officers. I wouldn't use it. I would give them the substantive protection of the business judgment rule, which is different than the way the business judgment standard review is framed. So I would give them a substantive protection, but I would not frame it in the director manner of this.
So if you were writing that brief, what authority would you rely on, or what reasoning would you rely on for that argument?
Two things, Gamble versus Stevens, and their agents, and under Delaware agency law, you ask this question: was a fiduciary duty owed? Was it breached? Did it cause damages? There's a lot of Delaware decision law.
Professor Thompson, I think.
Following up, Wyman, why do you need regulation by litigation in the language of the earlier panel, or regulation by fiduciary duty, when you have regulation by termination or regulation by overturning the agent's act? And so I think it's a different ballgame because of that. And if you do need it, I mean, what about federal law? Federal law has specified duties of officers. You have a duty to certify financial statements of your CEO or CFO. You have say on pay, which lets shareholders vote on officer pay. And so what's happened is you have officer clawbacks that are in federal law. So what we have is, outside of Delaware law, we have a whole bunch of private ordering going on with termination and just reversal under, and then when it's not working, we have a whole bunch of new federal law. So isn't this an area where Delaware has been hit from two directions, and there's not much left?
Yeah, I mean, I think it actually is an example of your collaborative federalism. I think it's been going on for a long time. I do think, though, that it's important to articulate for these people strong rules so they know going in. It's not just the employment agreement. I mean, the Disney case got litigated that way, but you could have teed it up as, hey, there's some officer wrongdoing here, and you need to address it as officer wrongdoing. So I believe, I'm like Gordon on the demise of fiduciary duties. Fiduciary duties aren't going to last if society doesn't care about these norms. But to the extent that these norms still have social salience, I think we should communicate to them, at least occasionally, that they apply at the highest level of the C-suite. Now, are there going to be very many in these cases? No. Are the boards going to deal with most of them through settling up? Absolutely. And what doesn't get dealt with, the feds will deal with. But I think that's different than never articulating rules historically.
Joe, you had a question, I want to get it Delaware.
Yeah, so this subject was a matter of interchange between Larry Hammermesh and myself and Lyman over a course of about 10 years. Larry and I wrote an article. I don't remember who wrote the first one.
You wrote the first one.
We wrote the first article, he wrote a response, and we wrote, I guess we call it rebuttal in litigation terms. I don't remember all the things, I'm not sure I remember what we disagreed about, but I do remember some of the things that Larry and I talked about. We would have applied the business judgment to officers, but with some tweaks to recognize the different status that they had from directors. So we would have implied a duty to report up, which addresses one of the questions that somebody, one of the comments somebody made about Enron or whatever. That would have been a duty that directors didn't have, but officers did, and could be deprived of the business judgment rule if they didn't do that. But we also recognized that officers would only be protected if they were operating in their delegated sphere of influence. So, for example, if you had the treasurer of a company out negotiating some merger agreement, as distinguished from the CEO or the CEO's designee, that person would not be covered by the business judgment rule because they were operating outside of their delegated duties. But with that, we thought the business judgment rule would apply pretty much full force. And I still think that if you go look at the case, if you look at what gets cited, I think those three articles have really filled the gap in terms of the case law in this area. I know various courts have applied it.
I have to let our
It may stay that way for another 10 years.
Well, it may, and the fact that it was raised and put out there just says something about I don't say how important this issue is, but it hasn't been one that's cried out for action. And also, there was this back and forth about agency. Officers are agents to third parties. They can bind the corporation, but if you're talking about something an officer does, make it easy, embezzle from the corporation and the shareholder sues to get the money back derivatively. I mean, that's purely internal. It's an internal affairs matter. Now, that person may be separately prosecutable, but in the context of a shareholder suit, that's just got to be an internal affair.
Steve?
It's been a fascinating discussion, but I think we're missing, a very large piece of this discussion. And I guess this is an example of Bob Thompson's collaborative federalism, but what Delaware does with officer liability is almost irrelevant given the rising use of the responsible corporate officer doctrine. I do a lot of work with the Washington Legal Foundation, and we've got a brief asking the Supreme Court to take cert in U.S. versus DeCoster, which is this just amazing case where the two brothers who were the CEO and CFO of an outfit in Iowa called Quality Egg, their company, they had a salmonella outbreak at their factory, and the FDA came in, and the DeCasters had completely cooperated, voluntarily suspended sales, recalled everything. The FDA came in and hit them with an indictment under the responsible corporate officer doctrine for alleging strict criminal liability, that they would be strictly criminally liable for conduct committed by low-level corporate employees that the FDA admitted that the DeCosters had no knowledge of until well after the fact. And so this is an example of where the aggressive use of the responsible corporate officer doctrine is really occupying the field of officer liability in a way that state law hasn't. And I don't know if you saw this, but there was actually an op-ed in the Wall Street Journal yesterday, I believe, by a former CEO of a medical supply company who resigned rather than get sued again under the RCO Act. So I think that in assessing sort of federalism, Delaware, officer liability, we have to plug in the RCO doctrine. I know your paper talks about the Yates memo, but I think it would be really, this is where the action is today in that area. And the number of suits, I had a former student, SJD student, Martin Petrin, has written in this area. When he went out and crunched the numbers of suits were just astonishing. Well, many more RCOs say suits being filed than fiduciary duty suits get filed in Delaware.
We have a couple questions I want to get to. I would just ask Gordon a quick question first.
I'm going to pass because I'm enjoying much and mine would get
Well, let me squeeze in a quick question anyway, because it relates to the topic of the seminar. If I read your abstract correctly, you said that one of the threats to Delaware's dominance is the corrosion of the duty of loyalty over time. So I guess my question is, how long will it take for that? A month, a year, 10 years? What's your prediction?
I think it's already happened. And the question is whether, whether it has happened for a good reason or a bad reason. I mean, I have a separate paper, which will probably never see the light of day now, but talking about how the reason this has happened is that Delaware is trying to essentially facilitate action. It's trying to put assets into, it's to make corporate assets dynamic rather than let them get static, and this is a way, letting insiders deal is a way to sort of move things forward when they've gotten stagnant. That's a really sort of happy story about it. The unhappy story is that corporate insiders see an opportunity to take advantage of the minority outsiders, and they use conflict of interest transactions to do that, and Delaware is facilitating that. Actually, those aren't mutually exclusive stories, right? I mean, it could actually be both of those things. I think, to me, that's the more interesting question. I think we've long left the day when we have Minor versus Salmon and Calif versus Law sort of duties. I mean, at least Delaware, I just don't think they think about it that way anymore. And there's that sort of somewhat controversial Marsh paper in 1967 about the corruption of loyalty. He didn't call it that, but that was essentially the thesis. And I think that's, I think he was largely right about that. I mean, the law has substantively changed to make it so that fiduciary duty has less teeth.
Do you think that's a threat to Delaware?
I think it could be, because I think if all Delaware is doing is essentially interpreting contracts, it's not clear to me that we need the Delaware courts to do that.
Well, then we have a bunch of other questions. I'm not sure how much more time you want to go on.
No more questions, gentlemen.
Charles had one.
Why don't I take Charles and Bill and then we'll break for lunch?
The idea of Delaware officer liability, could there be an explanation that's a little more pecuniary in the sense that, why rob a bank, that's where the money is? And historically, if an officer stole, there was always a contractual claim against the officer, right? The shareholder should sue the company would sue. But for a shareholder to sue an officer for a bad act, there'd have to be some value. The officer had to have some money. Historically, the officers, whether it was even the CEO, they weren't paid that much. And so what was the point? What were you going to recover? This is long for D&O and whatnot. And maybe there is a pecuniary explanation. Directors historically, remember, were large shareholders. There was money there. But if there was no money, what's the point? And perhaps that explains partially the failure of the document. Well, I don't know, but that's what struck me. Why sue someone if you get basically nothing? I mean, it's fun, I guess. But what's the point?
Before the Yates memo, there was still federal enforcement of the securities laws. Jennifer Arlen and I did a paper about 25 years ago, if I can remember back that far. And we found that most of the fraud on the market was financial fraud, financial misstatements, and much of that was to cover up officer failures. So the prosecutions arose in a lot of those cases. So this goes along with Bob's comment about the role of the federal government in enforcement. They played a role in enforcing against miscreant officers.
Great, I think we're out of time, but thank you very much. All right, ladies and gentlemen, we are in the final home stretch, I suppose, and delighted to introduce the final panel. Charles Elson is the Edgar Willard Chair in Corporate Governance and Director of the
John L. Weinberg Center for Corporate Governance at the University of Delaware and of counsel at Holland and Knight. He's a graduate of Harvard College and of the University of Virginia, where we were actually law school classmates. I've known Charles longer than I've known anybody in this room. And
Has he improved with age?
he was already so admirable that there really was no room for improvement, but I would say yes, nonetheless.
Like a fine wine.
On a subject on which he's a leading expert. He's been a visiting professor at a lot of law schools, has written broadly on corporate law, and remains one of my oldest and dearest friends. Hilary Sale, of course, at Washington University in St. Louis, frequent speaker both at industry and academic conferences on corporate law, and of course in recent years has taken, well, I guess for lack of a better word, a leadership position in the issue of women's leadership, and is currently the Sullivan Cromwell Visiting Professor at Harvard Law School, the co-author with Jack Coffey and Todd Henderson of a casebook on federal securities regulation, and has written, practically on every subject in corporate and securities law that matters. Gil Sparks is one of the deans of the Delaware Corporate Bar. He is now a consulting member of the Corporate and Business Litigation Group and the Corporate Counseling Group at Morris Nichols, Arlington now. He is one of the leading figures in the Delaware Corporate Bar, and indeed Chambers USA Magazine described him as the dean of the Chancery Bar. He's one of the leading M&A lawyers in the country. He and I served together on the ABA Committee on Corporate Laws, where he was a wonderful colleague to work with, and I enjoyed very much getting to know him there. And we're going to start with Professor Sale, and then Charles Elson, and then Gil will wrap it up. So, Hillary.
Thanks. And thank you to all of you. I do want to say just a particular thank you to Steve and to the other people from UCLA who've been such gracious hosts and hostesses. It's been a lot of fun to be here, and gosh, I mean, who knew that officer liability could be so darn interesting? That was really, that was a delightful discussion, raising for me actually, I don't know that I've ever thought a lot about the internal affairs doctrine, but it prompts me to want to write about it in a way that Gil would not like. So maybe I'll do it just for fun, because I too have worked with Gil for a long time and am a big fan of his, so it could be a lot of fun to do that. So this paper is a book chapter, and it's actually for a different book, and it brings up some of the issues that I have been interested in for some time, and I have another piece I'm gonna write about this in a slightly different direction, so I look forward to people's ideas and comments. What I do in this piece is raise this question about sort of what is this nexus of contracts theory and the basis of our theories about corporate law, and why do they not answer some of these other types of questions that we read, or that we talk about. So obviously the nexus of contracts theory in the world of corporate law and corporate law academia has had a very strong hold for a very long time, and I think it's a pretty incomplete story about how not just corporations and the actors who are members of that contract operate, but really more about how corporations impact society at large in ways that we don't talk about very often in the corporate literature. So for those purposes then, the nexus of contracts theory is very incomplete. It focuses on the internal parties in the corporation with very little focus on the external parties who are impacted by corporations. And I think that's equally true of some of the more recent theoretical pieces in corporate law, which has said that the nexus of contracts theory is incomplete. And here I'm talking about like the asset partitioning work and others, which also really don't address external impacts. But corporations, of course, don't just impact shareholders, and they don't just impact creditors. They are, in fact, public creatures. They are at least not entirely private. They exist as private entities solely by permission. This is something that I actually really only thought about when the Corporate Laws Committee asked me to write an article to celebrate the anniversary of the NBCA, and I was thinking about the definition of the corporation, and the definition uses the term private, and I thought, well, what does that actually mean to be private? And that is when I first started thinking about the fact that they're not as private as we like to talk about. And I know we do it for lots of reasons that are both convenient and make lawmaking easier, but I think when we focus on it too much, we miss the other piece. So they exist as private solely by permission. That status as private is actually defeasible from the public. And it comes from the legislature, but the legislature itself has its roots in the public as well. And this publicness, as I like to refer to it with respect to corporations, is at least, I think, a partial explanation, although not a complete one, for why we regulate corporations so heavily, at least those that are traded in the public securities markets on the federal level. Markets, of course, have very significant importance to the public, and having markets that are not rigged, in which people are willing to trade, matters a lot. And when those markets are harmed, or when we have financial crises, that harm goes well beyond just the corporations that are traded in the market, impacting lots of other people. And of course, corporations really impact the public in lots of other ways beyond just the market, right? And by that I mean what economists would typically term externalities, so environmental harm or other harm, and they also provide good. So I'm not blind to the fact that corporations do lots of things that we want them to do, which is, again, part of the reason why we make a lot of these regulatory trade-offs. So in this piece, I think what I'm saying is that this nexus of contracts theory never really was, or arguably still isn't, a complete theory or sufficient for an understanding about how we think about corporations. And I would say even the existence of fiduciary duties sort of puts that argument that the nexus of contracts covers this to task. It really raises a question about the contractual space even for internal actors in the corporation. But in this piece, I actually focus more on some of the federal choices and the roots of those federal choices in limiting what are talked about as corporate contractual choices. So private, I would say, actually is a meaning that has its name, is a term that has its meaning maybe only in name and not in reality. Instead, publicness really operates as a constraint on corporations and their powers, and all of those, the entity itself and all of those powers devolve from the public. And arguably what has happened over time is not actually just regulatory competition, but the federal government moving right into Delaware's space and occupying it pretty vigorously, and I would say way more vigorously than Lynn, for example, this morning was willing to give credit to. And that occupation of the Delaware space has really grown both directly and indirectly, and the examples I use in the paper are examples on the direct side of the federal government speaking to issues which Delaware did not speak to. It left to the choices of corporations, and that would be, for example, whether the members of the board of directors have to be independent, not with respect to a transaction, but overall independent. and whether there have to be certain committees on the board, something that Delaware law does not speak to, and whether the members of those committees then in turn must also be independent. All of that is space that the federal government occupies. Delaware law still says that you can make loans to people in the corporation, but federal law says you can't, unless you're a company in the business of making loans. And there are more, I could go on because there are actually lots and lots of these sort of direct examples of the federal government occupying that space over time. But I think actually, for me, the more interesting piece is the much more indirect piece, which Lynn said, oh, it's just disclosure, but I think the disclosure itself is actually a space of federal fiduciary duty making. And it operates in that information forcing substance way where the federal government says, you know what, you gotta disclose what you have in place with respect to risk management. And in order to make the disclosure, you really gotta have something in place with respect to risk management. And when you have to have something in place with respect to risk management, you then actually have to go do something about risk management. And when you do that, the directors actually need to know what it is because they're the ones who sign the federally filed documents. And as a result, we've built a whole layer of disclosure-based duties that require directors and officers to act in certain parties. And why do we do that? Because there are people who are not parties to the contract who are directly impacted by those choices. And that is the public. And that indirect space actually grows all the time, incrementally and in some ways very directly. So Dodd-Frank, of course, created some new forms of that, at least one of which it seems the Trump administration has done away with. I would call that one not as strong of a fiduciary duty, but more of a human rights piece, right? A great example of publicness, but not so much in the fiduciary duty zone, and that's conflict mineral regulations. But it would take the Trump administration a very long time to get rid of the rest of these. I'm not saying they can't do it, because they've proved that they're pretty willing to go down this deregulatory path, but there's a whole lot there. And every time corporate directors and officers come together to develop these disclosures and make these statements to the public in their public documents, the contractual space contracts more. So the space for free decision-making or private decision-making actually just keeps contracting over time. And that disclosure requirement then, or any number of those disclosure requirements, it seems, turns out to be quite powerful. And they go across the spectrum. So there's a broad range of them, and I don't really catalog them in this chapter because it's too short, but I've done that work in some other places, including with Bob Thompson and Don Langford. It doesn't just happen through the regulations themselves, I argue, but also through the litigation of the regulations. So when the courts opine on these issues, that also has the potential to have the disclosure requirement itself take on some new meaning and further expand those duties. And interestingly, unlike Delaware law, which tends to be very process-focused, this disclosure law is actually about substance. It's not about process. Putting aside how hard some of these cases might be to bring, just having a process to disclose something is not actually sufficient under the federal securities laws. You actually have to have the right kind of disclosure in order to avoid liability, and that disclosure actually has to be more fulsome than you might otherwise have thought. Okay, and then finally in the paper, I talk briefly about enforcement and the role that enforcement on the back end also plays in this context, not just through private, so-called private litigation over these matters, but also in the form of government enforcement. But either way, I think you look at it, whether you look at it from the sort of enforcement side or you look at it on the front end side, I think the question about whether Delaware can be dethroned the answer to that question might actually be that it already has been dethroned to some extent by the federal government. And the real question is, how much and how much more. And I just want to say one further thing about this, and then I'm going to sit down. Part of this, I think, happens just because Delaware's approach isn't statutory, it's common law based, and as a result, we get information out of Delaware solely in response to transactions. But what the federal government's requirements are living, ongoing requirements. They're not transaction-oriented except in the offering context. And so there's the potential to cover a lot more territory there, depending on who's in power and who's making the regs. Thank you.
Charles?
First of all, I want to obviously thank Steve. I can't believe we've known each other 35 years. That's so amazing. It's incredible. Wow. Steve in law school was considered probably, well, Steve was considered an extremely smart guy. And he remains an extremely smart guy. That was he back then. I can play in the records he loved anyway. But he's really old and irreverent and a lot of people. You know, it's funny, talking about this is kind of interesting. The title of my paper has changed a little bit. Originally, I sent in the abstract. It was why Delaware has endured, should endure, may not endure. And I changed it to why Delaware must retain its corporate dominance. Since I kind of thought about this, my views have developed quite a bit, and I want to speak to that today. But to begin with, before I came late last night. I had on a board of a Delaware corporation in Birmingham, Alabama. I told the folks that we finished up our meeting and come out here for this thing. General counsel was thrilled. He said, "That's great. It's been really interesting." The directors looked at me like, "God, what is more painful, that or root canals?" And it kind of made the point to me as to why Delaware endures, in the sense that not that many people are that interested or worried about it. The status quo remains, and that probably explains quite a bit of why we've been around for such a long time. There aren't that many of us to make us think about it one way or the other. And one day, if there is, then that becomes an issue. But Delaware, its endurance, Delaware's prominence, is really, as y'all heard earlier, an historic accident. It was basically, we went from New York to New Jersey, then on to Delaware, thanks to, you saw that, I think Woodrow Wilson was terrific. Did you ever hear the Norm Beasy Woodrow Wilson joke? Can I tell it? You've heard it. You ever heard it? Oh, it's great. Chief Justice Beasy used to tell a joke, thank God for Woodrow Wilson for Delaware. And I don't know why this really matters, but it's kind of funny. You're always supposed to tell a joke, particularly in a direct presentation of Delaware. And Woodrow Wilson, apparently the head of the highway department in New Jersey, Wilson's governor, dies. And Wilson's private secretary calls and says, "Governor so-and-so has died." It's 3 in the morning. And Wilson said, "Well, it's 3 in the morning. Why is that important?" He says, "Sir, I'd like to take his place." And then so Wilson said, "Well, if the undertaker doesn't care, neither do I." It's nothing. That was Chief Justice Beasy.
Are you sure you remember?
I was pretty good. Anyway, but thanks to an historic accident, Delaware. And it turns out it was extremely well suited for a lot of reasons. We developed what I believe is a sophisticated and advanced corporate code. Grammar and repetition notwithstanding. And also, more importantly, you developed a superb judiciary to interpret that code. Because most of corporate regulation is not statutory, it's interpreted for obvious reasons. And the court developed its reputation for intelligence. Those who go on that court have significant business corporate law experience. And it is viewed as a fair, neutral court. Neutral in the sense that there's really nothing else in Delaware, no local business interest to sway a court one way or the other, or to have the court viewed as responding to local interests, other than the corporate law interest, a la getting it right. And that makes a lot of sense. In other words, there's nothing, we're sort of the Switzerland, if you will, of corporate law. There's no local pressure on the court traditionally that would suggest some sort of local corruption. And that's why when decisions come out, people quibble about them. A plaintiff or defendant or someone is obviously a loser and unhappy, but no one generally questions the integrity or
or neutrality of the court. The court itself is viewed without special interest or unaffected by special interest, whether they're political interest or personal business-related interest. Too small a state, there's nothing else there. And that has been terrific for the state, in the sense that it has created a national corporate law, right, administered by these 10 judges, 5 chancellors, 1 Supreme Court justices, and viewed affirmatively and positively around the country and around the world. And that's been quite significant. It's uniform, it's stable, predictive. It's had its issues. I mean, people have been critical of it in the sense that they've argued over time that Delaware was too managerially biased. I wouldn't agree with that. I think that Delaware has always been protective of capital, investor protective. That definition of how you protect an investor has changed over time. Historically, it was management protects the widows and orphans. They're great fiduciaries. Today, we see a more balanced approach between the prerogatives of institutional shareholders, large shareholders, and directors, court-centric. It's a delicate balancing act. It seems to either make everyone angry or no one angry. And the point being that it's down the middle, and I think quite wisely done. So, why are we talking about the problems of Delaware? Well, Delaware does have competition. Number one, the other states. Nevada and North Dakota made a direct run at Delaware. Nevada adopted a statute that was probably more pro-managerial, as we saw. North Dakota's is in fact more institutional shareholder friendly. Carl Icahn had a lot to do with it, and it looks a lot like Carl Icahn. So you have these two competing regimes competing with Delaware. Delaware's somewhere in the middle. Neither have been successful, really. And I think the reason is very straightforward. It's not the law itself, it's the judiciary that interprets the law, enforces the law. That's been the issue. The judiciary in Delaware is a superb one, and neither of the other 2 states have been able to reproduce it. And the reason is pretty straightforward. To create that kind of court, you've got to have a significant corporate bar, and it doesn't really exist to the same extent in those states that exists in Delaware. And to set up that kind of mechanism that we have in Delaware would take some political changes here, but vis-a-vis appointment of judges, vis-a-vis establishment of certain courts, and it frankly isn't worth it to them. The money, the revenues they gain by those changes aren't all that important to them. Delaware, it's critical, but we're a tiny state. Those are much larger states, and the taxation benefit, revenue benefit, is just never going to be outweigh the expense to set something like that up. And that's why they frankly haven't succeeded. So, what does that leave us with? The feds. The initial sort of assault on Delaware for the feds was through the threat of a federal corporation statute. That was Bill Carey's and Ralph Nader's idea. It's an idea that frankly started in the 70s. It's still been taken up by other, disciples, acolytes. Late Harvey Goldschmidt was obviously very enthusiastic about that for many years. But that never went anywhere. Why? Federalism. The 2 representatives of Delaware in the United States Senate, they weren't going to allow it, couldn't allow it. It'd be too devastating to the state. We never got that statute. But what happened instead, either initially through disclosure, or now through a sort of direct assault, a la Sox and Dodd-Frank, on the Delaware regulatory franchise, whether it's compensation committee structure function, audit committee structure function, voting, it's now been federally regulated. Now, is it a federal statute? No, but it's removed a lot of the Delaware court's subject matter, their jurisdiction, their control over the functioning of the corporate board is now shifted to the federal level. So, does that mean the end of Delaware? It's a real problem for Delaware. Why? Because it makes the Delaware courts irrelevant, or less relevant than they used to be. Because at one point, they decided what audit committees did. They would decide what how compensation would be formed. Today, it's a subject of federal regulation. And in that respect, it's not the danger of Delaware being taken over by a federal statute, or the danger of another state stealing Delaware's business. It's the danger of irrelevance. And if you become irrelevant, your courts become irrelevant, which is the whole reason people were there to begin with, the statute and those courts, then what do you do? Why incorporate there? Why spend the $180,000 a year to do it? And the answer is, you're probably not. You'll go back, if the courts aren't relevant, you'll go back to your state, your home state, and take advantage of the corporation laws there. Why? Because the judges of your state are irrelevant as well. The relevancy is on the federal level. And in that respect, the federal intervention into the area is a danger to Delaware. It's not that they're going to take our corporations away. People will simply go to the places in which they originally were created because it doesn't really matter in the resolution of corporate disputes that you have the Delaware judges involved. That's problem number one. Now, the problem with that is, in a way, maybe Bill Carey won. Maybe you did get a federal statute. But you know the old joke, careful of what you wish for. This is why I say, why Delaware must retain its dominance. Why careful of what you wish for. Because if you wish for a national regulatory scheme that they found, and they have that theoretically in Sarbanes-Oxley and in Dodd-Frank, does that mean we're in the promised land for those folks? And the answer is no, really no. Because the goal was a national, progressive corporate regime, but you end up, yes, with a federal regime. But how are federal regimes enforced? Courts are necessary. Because there are questions on statutes. Statutes are never very effectively drawn. So who's going to enforce this? Federal district courts. Usually federal district courts. Who are the judges of federal district courts? Are they corporate lawyers? No. You don't get to be a federal judge because you were a great corporate lawyer. Corporate lawyers, A, there aren't that many of us, and B, you're never that political. Who's there? Prosecutors, defenders, defense lawyers, that's who's there. What interest do they have in corporate law? Not a lot. Federal district courts are also a product of localities. You get to be a federal district judge because you were active politically in that locality. Which means that the judge who's deciding a, quote, national corporate case, A, doesn't have a lot of experience in the area or interest, and B, is a local product, subject to local biases, right? So we're basically back with the federal model to where we started. The reason Delaware became important was no local bias. So you end up with a system where you have hundreds of federal judges deciding cases on which they have little expertise and local biases, which will create a disparate set of rulings, the balkanization of corporate law. Okay, you say, well, we got the U.S. Court of Appeals, we got the Supreme Court, they'll ensure national consistency. But those two are places without corporate judges. Again, you don't go to the Court of Appeals or even the Supreme Court on that basis. The number of corporate experienced lawyers in both courts is pretty small. So ultimately, while we saw it, they saw it, this great national system, we end up instead back to a localized, balkanized system, but might not be as progressive as they thought. And that's why ultimately Delaware, I think, should survive. Because it creates a national law, a balanced national law, free from influence, that can be respected by all. Now, does that mean everything is terrific? No. Delaware has some internal problems. Really, basically two. Number one, Delaware it's important revenue-wise that it carries out this, continues to maintain this corporate regulatory structure. But like every state, Delaware is revenue hungry. And recently, in an attempt to bulk up revenue collections, they began to get very aggressive on something called the escheat statutes, or unclaimed property. Basically, this is monies that people don't claim in a corporation, and the state escheats to the state. And Delaware got very aggressive, extremely aggressive, and it upset a lot of its corporate clientele. Forced a couple of other states to sue the state, successfully, by the way, in the U.S. District Court, where the judge was particularly harsh on Delaware's overly aggressive actions. The difficulty there is you're suing the very people for this tax who make your business. It's basically punching your clients in the nose and smiling while you do this. But, and that created a lot of bad rules. The legislature has now stepped in, they're backing off of it, that's a problem. Secondly, it's overly aggressive use of the revenue that they're getting, if you will, from this regulatory structure. Second and finally, is the most concerning of them all. Delaware, as I said, the courts have been considered neutral territory. Very recently, there was a case called Transperfect. This we'll talk about it, Thomas talked about that, which was a challenge basically to a closed corporation statute, dissolution due to deadlock. And a disappointed litigant mounted a significant public relations campaign to overturn the ruling of Chancellor Bouchard. Just recently, the Supreme Court affirmed Chancellor Bouchard's approach, which was considered a very standard, appropriate approach. But this individual spent a lot of money, had to set up a public relations firm, chants, rallies, marches, citizens for pro-business Delaware. Bizarre. But it's such a small state, It doesn't take that much money to put ads on radio, television, etc., to basically overrule the court on a particular issue. Thank goodness the Supreme Court didn't fall prey to it, but there is concern that there may be a legislative change in response to this campaign. That would be disastrous because Delaware was always above that. And if suddenly you introduced politics, if you will, into the process, you've got a problem, a real problem going forward. Secondly and finally, Delaware historically has a balanced judiciary. Constitutionally, it's equal numbers of Democrats and Republicans. It's designed to take politics out of the judicial process. Delaware, like some states, has become a one-party state. One party dominates. And the concern is, with the domination of one particular party, even with this balance, that political considerations begin to influence the way we pick judges. That hasn't happened. But if it should happen, that would be devastating to the state. Because once again, that's where the state decisions of our judges become suspect because they are subject to local political considerations. That would be a disaster. Delaware, in other words, the enemy isn't only on the outside, the enemy may be within too. I'm hoping this doesn't occur because I think ultimately the Delaware system of regulation is significant to creating an effective national body of corporate law that balances the interests of everyone involved. I'm on this kind of the shareholder side. My old friend Steve is on the director's side. That's a good thing because we can argue about this and we can have a great debate, and the courts basically balance between the things. Some things he's delighted with, some things I'm delighted with. Many things we're both unhappy with, and that's the way it should be. That's an effective judicial system, I think. And I think if Delaware does lose its dominance, whether to the other states, I think we have a real problem. And with that, you didn't even have to get to the C2
Good job.
Thank you.
Gil?
So here we are at the end of the day. I'm the only person standing between all you guys and gals. The first glimpse of sunshine I've seen since I came here. And you won't have to put up one of those signs. In part because a lot of what I was going to say has already been said. It's been said by others, some of it's been said by me. I would like to start, though, by saying I'd like to change the title of this program, as I heard. And that is, why would anyone want to dethrone Delaware? I mean, the pictures of chaos that Charles just pointed out, if you were to completely dethrone Delaware and throw us into a system of some sort of federal incorporation system with hundreds of federal judges, colonial federal judges, and truly great people, would end up deciding on law. I mean, the things that we started the very conference with, uniformity and certainty, would be gone. They'd just go. I've had the experience of trying to litigate Delaware law principles in foreign courts. Remember one example in a place called Weirton, West Virginia, involving a company called Weirton Steel. And the late, great Frank Bellotti and I trucked. We went out, I don't even know how we got there. I don't even get an airport. And finally, we had it in Pittsburgh and we drove. And we ended up in some sort of storefront courtroom over a store. And one of us started to make the argument about they haven't made a demand, and therefore you need to dismiss this case. And the court looked at us and said, you mean you're telling me that the people who are suing these directors have to make a demand upon them to sue themselves? And he says, dismissed. You're out of here. I mean, your motion denied. You're gone. I mean, when you never even got to the substance, and that's the kind of thing you run up against if we had the non-uniformity So let's just quickly recap, and I'm going to try not to repeat anything that Charles said, or I'm going to do it in 2 words, so I don't really. Structural basis for Delaware's dominance. Annual legislative updates. As soon as the first legislative year is over, the council is already looking at what's in the queue and what will be done next. Corporate counsel composed of experienced practitioners with plaintiff side and corporate defense side practices And notwithstanding anything you heard about sort of feathering your own nest, it's always been a tradition that you leave your client's interests at the door. Court of Chancery handles cases, there are no juries. Judges are apolitical, we've done that. Judges are regarded as honest, highly intelligent, and due to Chancery's unusual docket, are highly experienced in corporate cases, even if they weren't corporate lawyers when they started being a chancellor, because if all you see are there's tons of corporate cases, you become an expert pretty soon in what you're doing. Single level of appeal, and it's all quick. You get an expedited trial in important cases in a matter of months, and it just matters to move along. Extensive case law. There's a tradition in Delaware of writing all these long opinions that you see. You don't see that in other states. Judges don't have time. But in Delaware, even some of the smallest cases get 40-page opinions. And then you add that all up and you have this huge body of case law where practitioners can find answers to almost any corporate law question, or at least more so than any place else. And then, significant because corporate planners and business people can plan around and account for known risks. And I've heard all this stuff about indeterminism. The fact of the matter is there are plenty of rules. Take the M&A area. Everybody knows how to do a good merger. Now, they don't always do it, but they know how they should do it if they're well advised by counsel. Those are rules. I mean, it's process. And then more and more we're now seeing, as these rules become fixed, that the courts are more and more reviewing process, not substance. I always said if I ever became a judge, or the one reason I wouldn't, well, there are a lot of reasons I wouldn't and didn't, but one of the reasons was I never wanted to do an appraisal case, because I know that most of these judges, maybe some of them are smarter than I was, but you know, sitting here looking at these discounted cash flows and these multiples and all this junk, and I've had to litigate some of those cases. You know, it just gives you a headache to think about. And you don't want the courts deciding entire fairness cases either. Same reason. These are judges, they aren't business people, and you're asking them to do something that's unnatural. Due to its dominance, corporate law practitioners are generally comfortable with Delaware law. A lot of you are law professors. I would suspect that 90% of the corporate law that you teach is Delaware law, and maybe 10% is Utah law, 10% is California law, but everybody's trained in Delaware law, and that makes people comfortable. That makes the people who recommend where you incorporate, like general counsel, more comfortable because they know it, they've learned it. And then on top of all that, it's not even close to the most important thing, but it's important. We have a very, very efficient, high-tech, instant service corporate processing system for filings and the like. And very responsive, you know, do your merger at midnight if you ask them. And it's a lot of resources have been put into that system by the state. So that's efficient. So we've got 66% of the Fortune 500. We have a large percentage of new incorporations, or new IPOs. And with this, Delaware is able to chart a middle ground between the tension between board management and stockholders. And it's been that way for years. And we do that because we don't have to curry favor to either constituency or to any 500-pound gorillas in the state. Rather, we've always gone on a philosophy that in the long run, if we just do the right thing, because we're free to do the right thing, we don't have to adopt other constituency statutes or hyper-restrictive tender offer regulation. If we just do the right thing, everything's going to work out okay. And a couple of examples, I have a bunch of them in my paper. I'm only going to touch on a couple. But Unical is probably as good an example as you could come up with. I litigated that case, so I sort of lived with it. And when we entered into that case, there were only two standards of law to evaluate transactions. There was business judgment rule, and there was entire fairness. Sort of almost complete deference on one hand, and no deference at all on the other hand. And the question was, well, what are you going to do? How are you going to judge the defensive technique? What's a permissible defensive technique in this context? And the Delaware courts, much like the Delaware Corporation Law Council does in the statutory area, in effect, came down in the middle. And so recognizing that a defensive measure was a type of conflict, they could have applied entire fairness. That would have been very stockholder friendly. They could have applied the business judgment rule. That would have been very management friendly. Instead, they took the middle ground, and we all know that basically your defense had to be reasonable in relation to the threat posed. It allowed these transactions to move forward. It also taught people how they ought to act and what they ought to think, what they ought to be thinking about in making one of these transactions. 102B7. Everybody thinks, by the way, this came out of Van Gorkum. This came out of the D&O insurance crisis that began a year and a half before Van Gorkum was decided. And people were doing stupid things, captive insurance companies. So that had a threat to just bypass the whole statute and ran over the concept of what insurance was because there was no risk share. So they were doing that. There were other techniques that were being applied that were simply offensive. And what did we do to keep directors willing to serve in that environment? And so 102B7 was adopted. And it took a middle road. We saw some of that in a comparison with Nevada. For example, the thought of not protecting officers was very deliberate. In fact, I was chair of the Corporation Law Council for both 102B7 and 203, and so I had a reasonably large voice in all of this. And I've just had a chance to review all the minutes of our meetings for oral history that Penn is doing. And I have two reasons. Number one, our reason for doing this is to attract directors, make sure they continue to be willing to serve. We didn't need to attract officers, they were being paid. And the second reason was that as a policy matter, if you didn't protect officers, it would force them in the marginal case to report up to the board to cover their tails. And that's a good thing, because you want a report-up concept with respect to officers. And we also wanted an opt-in. So we said you have to do this by charters. If the shareholders thought that it was better to hold a club of duty of care liability over directors, and that was more important to them than getting good directors, they were free to make that decision. As it turned out, every now and then you see, there was actually a case last week or the week before that I read, where somebody had not adopted a 102B7 provision. That is so rare. I mean, everybody adopted it, and everybody loved it. The investors saw the rationale in it. The investment community, these things passed easily. The ISSs of the day had no problem with it, and it was actually a great success. 203, another example where we took a middle road. We didn't do any of this other constituency stuff that other people were doing, and we had a great debate on whether the exception, remember the structure of that statute is if you go from under 15 to over 85%, you don't fall under its restrictions. Well, Joe Brunfest was in saying it ought to be 75 or 80. Marty Lipton was very, very vocal saying it ought to be 90. And we ended up at 85%. Now, and that's another actually, and by the way, 32 other states had no exception where we had the 85% exception, and 2 others are at 90%. So we were able to use our lead, if you will, in this area to do what we thought was reasonable and right. Now it turns out that 203 is like a dinosaur because right after that, poison pills came along and basically made 203 obsolete, and what 203 was really targeted against was coercive two-tier tender offers, and they also went away. But the reaction, the way we were able to do it has not come back to sting us and yet satisfied all of our constituencies. And then finally, the only other one I'm going to touch on is, and we touched on it before, multi-jurisdictional litigation problems. The history of that is first the forum selection charter provision was selected, it was suggested by Vice Chancellor Laster in a later Revlon opinion, not the original Revlon opinion. And then Chancellor Strine upheld the forum selection bylaws as facially valid in the Chevron FedEx case. And then Chancellor Bouchard actually found in the city of Providence that a forum selection provision selecting only North Carolina, but not Delaware, was valid. And 115 came down, codified Chevron FedEx, actually superseded the city of Providence. And think about that in connection with Trulia, and that's sort of a middle ground. We didn't say you could only sue in Delaware. You can sue in Delaware, you can sue anywhere else you want. It's all private ordering. But this lets corporations defend themselves from forum shopping. And it ties in directly to whether or not in the long run Trulia is going to be effective or not. Because if you really are concerned about this multiple litigation problem, you're going to say only Delaware, or only Delaware and some other court, maybe North Carolina, it's business law court or someplace else, that is going to be, it's going to handle in some decent way the sort of hold-up disclosure suits. So I think the final chapter on that, to touch on something else, has yet to be written. So those are a few examples of areas where we have sort of taken the middle road because we could. And I think it belied, and one of the first things I was asked to do by Sam Marsh when I started practice was to write a rebuttal to Ralph Nader, some Ralph Nader article that I authored with Sam in the Hospital Law Review. So I sort of start my career fighting against federal incorporation and sort of maybe ending it here in terms of dealing with the same thing. So let's just talk a minute about threats to Delaware's dominance. It's cheap. Charles covered that. I'm not going to say another word to deal with it. Federalization of Delaware law. Full federal incorporation, theoretically possible, but seems unlikely to happen. It would be a colossal mistake and disaster. And I've got to believe that I have little faith in our legislature, national legislature. Even they would be able to figure out that they just couldn't dump this caseload on our overburdened federal legislature, or federal judiciary, who they hardly ever get around to confirming, without destroying all the uniformity and consistency. I know everybody would rise up against that. The corporate community would just go nuts. So I don't see that happening. I also don't see it happening, that kind of thing happening in a Trump administration, which I think is sort of oriented toward states' rights. Nobody knows really where they're oriented, but I would guess that they're more sort of oriented toward states' rights, get it out of Washington thing, and this would be a strange attack. We talked a little bit about the nibbling of Dodd-Frank and Sarbanes-Oxley. Things like you have to have an audit committee. You have to have a compensation committee. I really don't think these have taken, I don't think these have taken any real action away from Delaware. The question of whether an audit committee did its job or whether a compensation committee did its job is still going to be decided under Delaware law. The transactional question of whether or not they screwed up or whether they're entitled to the business judgment rule when they make some horrendous decision, that's going to be under Delaware law, and that's where the real action is. So I don't think any of those things. You can't make loans to officers. Who cares? I mean, it's just. I don't think you could find a loan to officer case in the whole history of Delaware case law jurisprudence. So I don't like it when we have these corporate crises. Some of them are particularly galling when, for example, Enron wasn't even a Delaware corporation, but it is episodic. My fingers crossed that it will remain that way, but I don't think a solution to those types of problems is going to come through material interference with the Delaware model. Talked about state competition. We talked about how the states can't reproduce the expertise of the Board of Chancery, at least without very significant investment. But it's also a matter of culture. And this brings me to one of the things that I think is a significant, well, it's not a significant risk, it's just a possible risk, because I see no sign of it. But think about the lawyers you know who have sacrificed careers at major law firms, sacrificed millions of dollars in compensation to go sit on the Court of Chancery. And it's sort of, it's just sort of tradition and a concept of public service. And it's hard to know how much of that depends. I mean, some of them would do it, they made their money at Scadden, or they made their money somewhere else, and they probably do it for nothing. But one of the problems with our $350 million budget gap, that'll probably close, it always does. There's something that comes in, it gets a little over, it always works out. But our state, like many states, is in a financial bind, and they've already, I believe, rejected any judicial raises for the judges this year. And that can't go on too long without people rethinking whether or not they want to serve. Don't forget, it's not a lifetime appointment. It's 12-year terms. It's not a lifetime appointment. What do we pay our people? $198,000 a year?
Less than one corporation's range.
Yeah, I mean, that's an area that does bother me, and that could, and if we ever got to a point where we had, call them judicial hacks on the Court of Chancery, the Supreme Court, then we'd have a real problem. And finally, we talked a little bit today about arbitration. I think that's the most interesting thing to talk about today. And I don't know quite how to scope that out. If you think about, if you go back and look at the Chevron FedEx decision, there's like one line in there that sort of says maybe the court was worried about that and is sort of trying to put it, and at least say we aren't deciding that kind of question. They said, there's a sentence in there that says that a forum selection bylaw is not preventing the plaintiff from suing. The reason for saying that has got to be some concept that if it did, maybe we'd have a different result. I'm not confident, though, that the rationale for saying having a charter provision or a bylaw provision that said all intra-corporate matters shall be decided by arbitration, I'm not sure at all that that's invalid. It may be against public policy in some sense that one can create something having to do with Section 109 unless otherwise contrary to law or something like that. So there's some risk there. The real question is, why hasn't anybody done it? Now maybe somebody has done it, but I haven't seen anybody have done it. And probably the answer is, and Lynn and I were discussing it, probably the answer is, why would anybody want to toss up their hypothetical, once-in-a-lifetime, big-time merger transaction to one or two or three arbitrators who you don't know who they'd be, as distinguished from the Delaware Court of Chancery and the Delaware Supreme Court. So I don't really think we're going to see that. I'm reasonably optimistic. I think Trulia is a problem. By the way, I thought Bill's paper was the trouble with Trulia. All I can think of, remember a Star Trek episode, The Trouble with Tribbles? Whoever wrote that was a Star Trek fan. But it's early in that game, and we just need to let that settle out. And I do think that you want to keep an eye on the trend of people who put in forum selection clauses, because they can sort of cure this. So that's it.
Thanks, Gil. It always is no fun going last on a particularly two-day conference. And I thank Gil for being willing to do it. I also thank him for ending us on the right note of a sort of full-throated defense of Delaware. Comments, questions, Glenn?
Yeah, quick comment on your last point, Gil. I mean, because equity in the Court of Chancery jurisdiction is constitutional, I think that you cannot shrink the Court of Chancery's jurisdiction over these internal disputes, but that's my own view.
I'm putting you on retainer. That's a great point. I hope you're right.
Yeah. Hillary, I mean, your paper started very sort of publicly, and I like that. I think the contract paradigm has always been inadequate and not even descriptively close. But then it ended up sort of turning internal again, that you talked about public and other constituencies and concerns, which I think corporate law gave up on when Bob and others traced how corporate law developed. And even the nibbling of the federal law, it ends up being very traditional. It's internal stuff. It's shareholders and officers and stuff. So it wasn't quite following the move from contract paradigm doesn't work, there's other people, to federal laws threatening Delaware, when in fact it's just doing what Delaware is doing different. Did I miss something there?
Well, I guess I would describe it differently, right? Which is, it's not doing what Delaware's doing because it's creating living requirements that you always have to have an independent board. And the rationale for that is that they will do a better job, right, of monitoring the conflicted agents in the corporation for the sake of the public and the public market. So you're right to say that I don't actually see it as healing. I think it's quite significant, these choices by the federal government. And I'd say they surprised me when they first started happening. Now they don't surprise me at all, right? We just got more with the second set of legislation. But I don't see it as nibbling to sort of have the federal government dictate the nature of the people on the boards. I do think that the way it's enacted, these sort of check-the-box financial approaches on the stock exchange undercuts that to some extent. But I don't see it as something that the government, so first of all, it's not something the government did just to regulate the internal affairs of the corporation. They actually did it to make corporations, at least I think that's what the statutes say, and that's what the legislative history says, they did it to make corporations be more outward-facing, in fact, and better other regarding entities. They don't use that term, of course, but so I think the rationale for it is something different. Whether it actually has that impact is a more complicated question, right? I mean, and the initial evidence on independence was pretty iffy, but the more recent papers in the finance literature on the business school side are actually increasingly saying this does make a difference in corporate decision-making in terms of risk-taking and other things, so.
For more than just shareholders, for other.
Well, so you can only measure it in certain ways, right? So those papers, of course, measure it with respect to shareholder returns and things like that. But the fact is, if the corporation makes fewer bet the company bad, risky decisions as a result of that, that's actually good for all of us, right? Safe and healthy markets are actually good for the public because when the market crashes, it's not just shareholders who get hurt, right? It's a lot of people beyond shareholders who get hurt.
Sean?
I just have one, I loved Gil's presentation, I just have one comment on the point at the end. I don't think that truly a plus a form selection clause solves the disclosure settlement problem for two reasons. Number one, form selection clauses are basically an option of defendants, right? So there's the fiduciary out provision in the form selection clause that says that defendants can waive in writing. And then the other thing about that is that the form selection clause is not self-invoking, so the defendants have to invoke it as a basis for a motion to dismiss in the first place. And so if the problem with these settlements is that the defendants want them basically defecting from the ex ante good, then the form selection clause doesn't solve the problem because they just don't invoke the form selection clause. And the second reason is that if they started to invoke them, plaintiffs would just file in federal court in a 14A9 action where that can't be brought back to Delaware or to Delaware.
Well, that is if you have a 14A9 claim.
But they're identical, right? They're mirror images So why wouldn't you? I
Well-
mean, wouldn't you always have that?
I'm trying to think if that's really right. I mean, but even then, you can tailor your, I guess I'd call it your form selection thing to include federal courts and state courts.
I don't think you can. I think that the securities laws have a section that say that only federal courts can decide substantive securities laws.
Well, no, I understand that.
So, I mean, so you could never get out of federal court on the 14A9?
Well, let's let that play out, see how that works.
The author of our securities casebook author wants to.
Actually, I didn't want to talk about that. I wanted to say something to Gil, so whenever.
Okay.
I think you'd give up your Revlon claim, but that's probably not important. And
Since you can't make a good one.
Michelle?
you don't care. So I want to also respond to Gil. You know, I think that Delaware is also taking another. I mean, this is an all going back to basic argument, but I think that with MFW and other cases, you know, Delaware is stressing again that we focus on process, and process actually it does provide some certainty. I think that you know, the M&A lawyers, when they sit in the boardroom, when there is such a transaction, a large transaction, they kind of know. The top M&A lawyers, they kind of know which steps they should follow in order to have the right process. They kind of know how much information director need to have, what kind of questions should be asked, and I actually believe that that's also right substantively. I believe the process is important in order to get to the right result. So, you know, I think that maybe we should kind of go back to this view that of what Delaware is doing, which has been there always, but was reinforced by recent, you know, MFW, moving away valuation decisions, and I also wonder whether MFW is going to have an effect on the amount of litigation in that respect. But I also think that, you know, this direction, it explains both the need in case law, common law, but also in a way that could provide some guidance and certainty.
Yeah, so I actually have MFW discussed in my paper, but I truncated it a little bit, but that's exactly the point I try to make in the paper. We're trying, MFW is an example of the court moving, frankly, towards some greater consistency in this law of what about special committees, and what effect do we give to them, and what about majority and minority votes, and what if you combine the two of them. And if you can get to a regime where that becomes the way people do it, that, to me at least, takes a lot of pressure off. A, it's rule setting, and B, it takes a lot of pressure off the courts because they are reviewing process. And one thing courts know how to do is review process and ask themselves questions like, was your investment banker conflicted, or did you check on that, or did the majority stockholder sneak into your special committee meeting and threaten you? I mean, these are things courts can deal with, as distinguished from having to figure out if something is entirely fair, which is really much more in the businessman's area. And
Which makes the Dell case in some ways even more puzzling. Bill?
Hillary, I think you've used a lawyer's characterization of the nexus of contracts description. It began with a piece by Jensen and Milken, economists, who refer to it as a nexus of economic relationships. It's quite a bit broader. It covers, you know, customers get implied warranties of fitness and this kind of thing. It covers employees. It covers, in many cases, communities where factories put in their deals made with the community zoning and all this kind of thing. And it covers also things like stock exchanges. New York Stock Exchange had rules before there was an SEC about the amount of disclosure of its property. So it's been a very broad world of nexus of contractual relationships, which federal law sometimes just displaces and preempts in ways that may or may not be good. I want to carry that on one step. My view of some of the federal disclosure regulations is that they've been special interest. CEO pay ratios, for example, conflict minerals. I think very few investors care about conflict minerals if we knew, how to identify them, which we don't. And the difference between Delaware law and federal law is Delaware law is quite neutral. One reason it's quite neutral is it's got a lot of competitors. If Delaware starts getting things wrong, there might be a change to another jurisdiction. And Delaware lawyers and legislators and judges know that, and so they stay on the straight and narrow neutral path. We don't get special interest provisions the way they do in Europe. You look at the Europe laws before there was any competition for chartering over there, and there still isn't much. You wound up with all sorts of special interest provisions in the law, labor protections, creditor protections, things we just don't see in this country. So I think there's a lot to be said for federalism, and I guess I'm happy to have Delaware lead as long as they stay honest.
Yeah, that was one of the points I made in my corporate governance after the financial crisis book with the 6 big corporate governance provisions of Dodd-Frank. You can trace every single one of those back to a specific special interest.
Yep. And
it's usually the Council of Institutional Investors. But every single one of those provisions had let's call them a legislative entrepreneur that had them lined up and ready to go. And somebody compared Dodd-Frank to the Christmas tree. Somebody had those balls ready to hang on that Christmas tree.
Actually, Steve, you
could say that about the PSLRA too, though, right?
Yes.
Brought to you by the accounting industry.
Yes.
And frankly, the
Well,
financial expert came
Well,
from the FEI. Came from Phil Livingston, financial executives. It's the CFO professional who brought you to the financial expert.
Right, that's true. And that's absolutely right. Mr. Lepecki.
Yeah, I wanted to go back to Hillary's remark earlier about tying risk to federal interventions. And I wanted to just find out what you meant by that. How does the audit committee, or were you referring to internal controls, or what was it that you were linking to risk?
I think I was, so the honest truth is I speak from very few notes, so I actually have absolutely no idea what I said. But in the article, when I refer to risk, right, I'm talking about the risk management regulations that the federal government has, which essentially tells you that you have to, you actually have to disclose what the risks are, right, what your material risks are. And in the process of doing that, you then have to identify them, you have to figure out what you're going to say, you have to figure out how you're going to mitigate them. I think it's a pretty good corollary to sort of care mark monitoring understatement.
Are you talking about risk factor disclosure?
Yes, yeah.
Because I don't think that has any teeth. I'm sorry, Lynn, but
No, actually, some of them are quite substantive, right? So there's a separate question about how comprehensible they are, right? And I just want to say this ties to something that Gil said in his remarks, which is, well, it's Delaware who's going to say whether audit committees did their job. And I'd say, no, actually the federal government says whether they did their jobs. They said it in Enron, they said it in WorldCom, and they'll say it again in other cases when audit committees screw up, right?
Well, Bill Chandler found ultimately that the Citigroup records were not liable because they had followed Sarbanes-Oxley. In other words, the federal standard defined Delaware, constrained Delaware's view of what was reasonable, unless it didn't come from the Delaware court, it came from the SEC.
But the point is, it isn't just Delaware that opines on this, right? So that is a sort of separate piece, but the fact is that there's a lot of stuff you have to disclose, which when you talk to directors about how they disclose that, they themselves don't go implement the programs, of course, right? But they have to make sure the program exists. And in order to do that, they have to know something about the program, and they actually have to have a conversation in the boardroom, and they have to have somebody come in once a year and report to them on whatever the program is, right? That's actually the substance of fiduciary duties.
I was really excited when I heard about the MFG case, and I was going to finally find out what internal controls were, and I went to look at the 10K where they had specified, where they had reported their internal controls and the assessment of their internal controls,
and it said, we have internal controls and we assess them as good. I mean, there wasn't any disclosure.
That's the auditor's assessment.
Okay, but there's no other assessment that's published.
The officers are supposed to.
No, I looked at
No.
both of them.
Yeah, but
to the extent that they're in the 10K, and they're just not there. There's just no substance whatsoever.
When they report it, the internal controls, they report it to the board. The audit committee of the board does discuss with the auditor. The audit committee chair then discusses it with the full board, reports to the full board. The full board
So only the board knows about this stuff. This is not a disclosure
No.
provision.
Why would you, how would you disclose? I mean, that would be like disclosing any kind of internal board discussions. Mere fact that there was an internal audit view of internal control, an audit view of controls, would have reported to the board. The board had to approve the K and had to approve the proxy rate with everything in it. So you know there was discussion, but to report the discussion would be pointless. It would certainly be lawyered anyway. You never did anything.
I would have found out what's meant by internal controls. So it wouldn't have been entirely pointless.
They should disclose it for Lynn.
I don't know, I just keep thinking about my all-time favorite risk factor disclosure. Was it Buffalo Chicken Wild Wings, where they disclosed that in the event of a severe outbreak of bird flu, their supply of chicken wings might dry up. And I can't imagine the board of directors having a program designed to monitor bird flu outbreaks, but maybe I'm wrong.
Well, they wouldn't have a program designed to monitor it, but you would expect management to tell them about it, and you would expect management to actually be tracking it in some way.
Really?
Well, South
Yeah,
flu-
possibly.
South flu is a risk factor in any sausage.
All right. Keith?
And now the Trump administration is gonna be the risk factor, I read in the newspaper. In the 10Ks coming out.
There are a number, there are already, you can
Yeah.
find Trump risk factors. But the Fed gives and takes away, and I just thought, in one area, maybe the federal government is giving a possibly small gift to Delaware, which is that they relaxed the intrastate offering exemption. It used to be a requirement that you had to be incorporated in the state in which you were doing the intrastate offering. And new rules, which will take effect this spring, will allow you to be incorporated in another state as long as you meet other tests. So for a state like California, which has a big population of potential investors, it would allow you to incorporate in Delaware or Nevada and still do an intrastate offering. And so for bigger states where people want to have a pool where they could just do an offering and raise funds from just one state, it may encourage people to go out of state where they used to just say, oh, you got to be California because you want to be doing an interstate offering.
Anybody who has this one? Okay.
So as I said, what I like about the lower case law, I'll say what I think I could be improved a little bit. I think that the focus process is really good because it does help to provide the right result. But the problem is that if the process is not good, the people who are on the line are the directors, and they're not designing the process. It's the general counsel, the outside counsel, and the management, that decide what's on the agenda and how much materials they're going to get and so forth. So I think that, one way is to look at Delaware cases and say, one of the roles of the cases is to provide guidance to the counsels, to the general counsels, and it does this job very well. But it does this job very well to those who want to follow the guidance. And in companies where the counsel is less, committed to that, and the outside counsel is many times picked by the inside counsel, or the management are less, they don't want to put issues on the agenda, then it's directors have less control on the process. So I think that, one way is to think about ways to kind of also shift some responsibility to the councils and the management for the process, and not only the directors. So that's related to the presentations about the officers' liability, right? which is, I agree, a puzzle, but maybe the puzzle is why plenty lawyers are not suing the officers themselves, and I don't have a good answer to that. But you see what there is some kind of tension here, because the directors rely on the corporate in-house counsel, and Steve also wrote about that. I mean, the corporate in-house counsel is also one of the top 5 executives, right? So it's almost too much to expect them to advise directors in the most efficient way to how to monitor it.
Maybe the best you could say about that is, well, number one, you would certainly be in favor of the Delaware Lawrence Seven model that excludes officers because it would theoretically allow you to reach an officer.
Right, but we don't have lawsuits in offices. I don't know what the explains that, why plaintiff don't sue officers, but officers are not on the line.
Well, they could be. I mean,
right, but it doesn't happen.
Well, it doesn't, and so why doesn't it?
You should file this case.
I mean,
Right.
I mean.
Yeah, no,
The plaintiff's bar has not chosen to go after officers. No, there's one D&O policy. It's not a separate one generally for officers. There's a single D&O policy. We have a director-centric system. The concept underlying the system is that the board will take the time to become informed and to cross-examine, if you will, the general counsel and anybody else who's formulating the transaction. In a major M&A transaction today, frankly, the general counsel doesn't have a whole lot to do with it. It's outside counsel that's really calling the shots.
Right. But there are many other decisions that are not M&A transactions.
Excuse me?
But there are many other decisions that are not M&A transactions.
Well, that's right, but somewhere the buck is, it's a little bit of a buck has got to stop here, and the Delaware corporation law and every other U.S. corporation law starts with the concept that the management of the business and affairs of the corporation is in the board of directors. So legally, that's where the responsibility lies. And you can have disconnects where boards are not well enough informed, but presumably the board ought to be making sure that it has the right advisors, and frankly, it's their responsibility to be sure that they have competent general counsel who is going to be candid with them and.
But they don't always have control. I mean, if they have this responsibility, then they should have the power to. But they do not have the power to hire the counsel, and they do not have the power to design the process. If the chairman is also the CEO, the chairman decides what's on the agenda, right? So the board doesn't have the power to determine that too. So there is some kind of tension. The board has the responsibility, but doesn't have the power of the process.
Well, the board does have the right. The board has the right to appoint every board committee. So this is under the stock exchange rule.
Right, but not the in-house counsel. Right.
Well, but you're talking to the guy that fired Al Chainsaw Dunlap. You know, I mean, boards have power.
Right, but he's right. Yes, but he's
and if they don't like what the general counsel's doing, they call the CEO in and they say fire the general counsel, or Charles Elson's coming for you, because if he could get rid of Al Dunlap, he can get rid of anybody.
Well, it's not that in intra-board politics. It's not that simple. And if the CEO is the chairman, they have to bring it somehow to the agenda. They have to ask the CEO to bring it.
How'd you get around that with Dunlap? Because didn't Dunlap have control of who could call a board meeting?
Well, yeah, Dunlap, under our bylaws, Dunlap had the authority, only the chair had the authority to call a meeting, but under Delaware law.
Scott paper.
Yeah, it's a Sunbeam. But
Sunbeam.
Yeah, but remember in Delaware law, if you show up to an improperly called meeting, you don't object, right? Meeting, your presence constitutes a waiver. And so at that one, we figured that if we surprised him, he showed up at the meeting, or was phoned by the meeting, and he didn't object to lack of notice and improper notification, and the meeting was deemed valid.
So I think
thank you, Dr. Delaware law.
The one thing that federal law did well was to require executive sessions, because
actually, that's Delaware doesn't. Stock exchange requires that.
Right.
Let's let Joel, you wanted to?
It might be worthwhile at some point to go back and look at the stock option backdating scandals. I was involved in a couple of those cases. In a couple of those cases I was involved in, plaintiffs' lawyers went after officers. They went after CFOs and general counsel. In both instances, the companies created a special litigation committee to deal with the demand, and it concluded that they were not going to go after those officers. Ultimately, the court upheld that judgment. But of course, the problem for a company going after an officer goes back to the financial reasons. Insurance is not going to cover that, because you have an insured versus insured exclusion, and so you just have an officer and whatever assets he or she may have.
Unless you like loans.
Yeah, right. But generally, for most CFOs and general counsel, it's not a huge amount.
I would, somewhat along the lines of Joel, is challenge the notion that officers are not sued. In the Dole Foods case, it was the CEO and the general counsel, large judgment, in Vice Chancellor Laster's court. For the last 7 years, I've been representing an officer of a public company who has been sued in derivative suits in California and Delaware and elsewhere. I mean, it's not totally unheard of that they get sued.
And being sued as an officer?
As an officer.
Because, I mean, the CEO is also on the board,
Sued.
so it's not like...
But Dole Foods was an egregious conflict. of
But,
loyalty.
I mean, I'm just saying
nevertheless-
there's examples of people
And
getting
there's
sued.
some restitution cases, that's what Lyman and I were talking about before, right? There's the Tyco restitution case. I mean, it's not the same, but it's a pretty good way to go after an officer who seems to have absconded with company money.
I'm just saying there are recent examples of officers getting sued, qua officers.
What plaintiff's firm brought that suit, do you know?
Which one?
In the one where you're representing?
Oh, there's several plaintiffs' firms, so, around the country.
Yeah, they get sued, Keith, but the theories are either loyalty, because Meg Shane did look at the data, they tend to be loyalty cases, which loyalty is really no different for an officer than a director. Don't engage in conflict transactions and make full disclosure.
Unjust enrichment.
Yeah. But that driver might be because it's almost impossible to bring a good case against directors under any other theory, right? So, how much money are you going to get out of a lawsuit against one officer on a care claim?
Anything else? Okay, what would you ask, Rachel?
Oh, Steve, just a question for the professors in the audience.
Sure.
What percentage of case books are federal law? Maybe that can settle this issue about whether federal law has
Mine's
really
about
taken over.
2% probably. No, mine's probably about 10%. Rachel, I want to thank everybody for what I think was a very enjoyable conference. I learned a ton. I came away with several ideas for articles that I probably won't write, but blog posts that I might. And I want to thank all the people that presented. I want to thank all the great questions we had. I want to thank our great moderators. I want to thank Joel and the Lowell Milken Institute for providing the resources that made this conference possible. The Lowell Milken Institute got a lot of bad press when it got started, thanks to a former colleague of ours. But it has been a real blessing to this law school's business law program and community. And it has turned out to be a great, I think, resource for us and for California. And mostly I want to thank Rachel Estrada. I would not have tried to organize this conference if it had not been knowing that she was there to do all the hard work. I just want to thank her publicly for being a tremendous resource for all of us and for doing a fantastic job at organizing the conference. I just want to appreciate it. And safe travels, everybody. God bless. Get home safely. Take care.
Thank you.